Okay, we will call the September 15th meeting to order. And Amy, may we have a roll call, please?
Mr. Fuller,
Here.
Mr. Colombo, Mr. Riddell,
Here.
Mr. Van Wagner, Mr. Ashkenazi, Mr. Maney,
Here.
Ms. Tallarico,
Here.
Mr. DeGenaro,
Here.
Mr. Guglielmi,
Here.
and Madam Chair.
Here. If we can stand for the salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, the notice requirements of the open public meeting law for this meeting have been satisfied. A copy of the notice having been sent to the Asbury Park Press and the Coaster and filed in the office of the Township Clerk on July 22nd, 2022. There is an emergency exit through the courtroom doors and 2 exits at the rear of the room. There will be no smoking, no new cases will be started after 10 p.m., and no new testimony taken after 10:30 p.m. In addition, the applicant will be limited to 45 minutes of testimony. All meetings will be video and audio taped and shown on the Township of Ocean's Community Cable Channel, Channel 22 on Verizon Fios, and Channel 77 on Cablevision. All cell telephones must be turned off, or if you need to make a call, please make your call outside the meeting room. First up, we have resolution memorializations. Larchwood Synagogue Incorporated, Block 8.02, Lots 3 and 23, 48 Larchwood Avenue, Ocean, expansion of conditional use approval, site plan approval.
Just do that one first.
Okay,
So I think Mr. Gazarovski has a statement.
Mr.
Madam
Gazarovski?
Chairman, members of the board, I have read the original resolution prepared by Mr. Steinberg, and there's been several modifications to that. I am here, and I want a question posed, because as I read the most recent proposed resolution, I want to clarify whether or not it means that until such time as the Law Division case is finally decided, that the applicant cannot go forward with any construction on the site, because it clearly says it's subject to the decision of the Law Division.
And Madam Chair, Jennifer Krimko on behalf of the synagogue. That's not my understanding either of the decision the board made or the resolution language. It's my understanding that we have an approval and it's subject to a court not overturning that approval by saying that the deed restriction is enforceable. If Mr. Gazarovski wants to stay, he has pending litigation right now. He is more than free to make a motion in the court to stay our ability to move forward. We are unless he appeals your decision and files for a stay and wins that motion for a stay, we have every right to proceed with construction, obviously at our own risk. To the extent that a judge indicates that either the deed restriction is enforceable and therefore we can't go forward, or overturns this board's approval, at that time we would be required to effectively take down whatever construction was made. So again, unless he has a judicial stay, I believe that the law is abundantly clear. As of right now, we have an approval.
I think the board has to look to its attorney for guidance in this matter.
Okay. The matter was approved. Both the conditional use variance, the bulk variances, and the site plan. But they are subject to the determination of a court as to his pending litigation.
I understood
Right.
they were subject to a, what if Mr. Gazarovski withdraws and there is no determination?
Or withdrawal. That's the other, it says that in the condition of approval, either withdrawal or a determination of a final court.
It was my understanding that this was subject to a court not making a ruling that we could not proceed because it was in violation.
Well, I think that if Mr. Gazarovski is concerned about your construction, as part of the pending motion, he certainly do file a cross motion for a stay pending final determination.
I don't understand what you said, Mr. In other words, let's assume for the sake of argument, we have this ongoing law division case going forward. Next week, the applicant seeks to begin construction on the site. I don't believe they're able to do that, predicated upon the language of the resolution. And that's why I wanted clarification with regard to.
This board does not have.
We don't have that jurisdiction to tell them what to do and what not to do. It is a condition of approval. If that condition is not satisfied, if they construct at their own risk, they would have to take everything down. I think it would behoove you. You're in front of the court right now to ask for a stay of any construction.
Now, Mr. Steinberg, respectfully, that was not our conversation this afternoon.
I don't, well, I'm not sure if they can or they can't. All right, I'd have to research it. But at this point, I think you need, it would be just as easy now to get a stay from the court. There's a motion returnable in October. If you're concerned that they're going to construct. If your agreement is held valid, the entire approval is vacated.
I understand that, but if in the interim, you know that we're not going to get a final decision from this court for at least a period of 1 to 2 years.
What? Unless
During that period of time, my understanding was with regard to the resolution as prepared, it's subject to the court approving or disapproving the application.
No, it's subject to the court not saying that the,
let me look at the language.
saying that the deed restriction is unenforceable. If no decision is made or.
Let me look at the language, and you may have to have a judge interpret it then. I do have it in here someplace.
Again, the needs of this Jewish community can't be held up for 3 years while Mr. Gazarovski and his client.
And you can argue in front of a judge.
But isn't this a decision of this board as to what their intent is? Was it their intent?
Their intent was to approve it.
To approve it, provided someone doesn't overturn that approval because of the deed restriction. So until you
I'm
have
not
a
sure,
judge
sir.
that says that
Ms.
deed restriction.
Krimko, I'm not a member of the board, nor are you. And I think this calls for, clearly, the input of the board is what it was they intended to do. Did they intend for the applicant not to be able to construct prior to receiving, one way or the other, a decision from the law division?
I'm looking for the exact language because I sent it out to.
And while you're looking for that, Mark, I'd just like to put on the record that, you know, you certainly can't hamstring an entire Jewish community and their future while one objector is frivolously litigating as to the approvals and this deed restriction.
What does it matter whether it's Jewish or Catholic or Christian or pagan?
Okay, ladies and gentlemen, here's the deal. We're going to wait for Mr. Steinberg to
The
He's going
language
to.
says that is conditioned upon the that the determination or withdrawal in the pending matter, and then we name the case, filed a determination which would preclude the action taken herein by the board. In the event the court of final disposition, after exhausting all appeal remedies, determines that the restrictive covenant would preclude construction to expand the synagogue and construction of the mikveh, which is the subject matter of the application, then the decision of the zoning board of adjustment approving the construction to expand the synagogue and construction of the mikveh shall be vacated.
Correct. So that language says it won't be vacated until such time it's been litigated to exhaustion of remedies. In no way does it say anything about commencing construction or that a judge's decision is a precursor to pulling building permits. Nor was that ever discussed.
Wait a second, that has not yet been decided by the board. And if you recall, at the last hearing, I raised specifically the issue whether or not this vote of resolution would be subject to the decision of the
Yeah, it is.
law division.
And
It is.
If
This is what we're-
if the law division renders the agreement enforceable, then this opinion is vacated.
Meanwhile,
That is
if that's
subject
gonna
to.
take 3 years, you're saying that you could demolish the existing structures and construct a mikveh and all of the other, that are going to it.
Yes, unless you seek a stay from the court.
Mr. Steinberg, I'm not happy with the way this is going. I'd like to get a vote from the board as what their intent was.
Well, I don't know if we have a position to vote at this point.
Pardon?
We voted already. Is the board?
There was different, what vote was there? I mean, basically,
The
it was,
vote-
and I was here, The matter was raised, there was a vote by 5 people, there was no comment being made by the board. I then stood up and say it's gotta be subject to.
It
They
is.
agreed, you agreed, now we're getting to the decision. Let the board say what their intent was. Because did
This
the
is
board
not-
intend for,
The public hearing is closed.
pardon?
The public hearing is closed. The public hearing is closed. on-
So,
on the
Mr.
application.
Steinberg-
I'm not asking for a new public hearing, I'm asking for
Yeah.
the board to determine and tell us
And-
what it was they intended to approve or not approve.
I guess to try to bring some closure to this, typically we vote on the resolution memorialization. So based upon statements or testimony, is that the appropriate vote at this time? So if the board does not want to memorialize it, they would vote no. If they do, then they will vote yes. Is that safe to
Yeah.
proceed that way?
Yeah, I mean, the question of whether or not this precludes construction maybe have to be determined. I don't think that it was the board's intent to totally preclude construction, that they could go ahead, but I think a court of law get you a
What does
stay.
it matter what you think the board's intent was? What was the board's intent? That's all I'm asking for.
If this, okay, the resolution as it stands does not preclude construction. It does condition the approval on a judicial determination or withdrawal that the restrictive covenant no longer applies. If it should be ruled that the restrictive covenant does apply and they do any construction, they'd have to restore the property to its original existence as it exists today. That's what this resolution said. If you're comfortable with that, you can vote on the resolution. If you feel that you want in the resolution that they can't do anything until this issue as to restrictive covenant is finally adjudicated, then we need to rewrite the resolution.
So I think based upon how we typically handle it, we will vote on the resolution memorialization for Larchwood Synagogue Incorporated
As it is written.
as it is written and how we typically vote, and the board members have the right to vote up or vote down.
Right. And if it's not satisfactory to Mr. Gazarovski or his client, then you need to just apply for a stay. You may very well be granted that stay.
So, Amy, will you please call the roll for that resolution memorialization?
Somebody
Motion.
needs to move
Oh,
the
or move,
resolution
sorry.
as it is written.
I'll move. I'll second.
Now, only call I think everybody was here for the case, though? Amy? You were not? Okay. Grace Ann was not, so it's only the,
Right, that was not.
John wasn't here. You only need one, you only need one member to memorialize the resolution. We have 5.
Yes.
Mr. Meany,
Yes.
Mr. DeGenaro,
Yes.
Mr. Pugliese,
Yes.
and Madam Chair.
Yes.
And now, that was for the resolution for the conditional use and the site plan,
I believe
both
so.
of which contain the same language.
Yes.
So as I understand it, the board has voted with regard to approving, to memorializing what you have written. They have not decided what, in fact, your intent was. All they voted on was your memorialization.
Right, and if you find that,
Thank you.
I think you need a court ruling if you think it's different.
That's what you said this afternoon. And I very rarely ever do that because we had a conversation. I offered to,
We went with the language, you approved the language.
pardon me?
You approved the language.
I did not approve the language. I approved the language predicated upon your
And then you-
advising the board.
All right.
Now, Mr. Steinberg, all I can say is I'm very disappointed.
Can we move on to the Krautler?
Yes,
Memorialization, please?
It's my understanding that the Arbor's case is adjourned.
It is.
So, which case? I'm sorry.
Arbors.
Thank you.
Seaview.
Oh,
Arbus case is going on. Seaview Corporate Park.
okay. Next, Thomas and Susan Krautler, Block 22, Lot 23, 229 Larchwood Avenue, Ocean. Certification of use approval. And I believe that Mr. Steinberg, that has to be done separately from the bulk variance approval.
I wasn't listening. I
Crowler.
apologize. I was
That's
checking.
okay. Krautler needs the certification of use approval has to be voted separately from the bulk variance approval, or can they both be voted?
They can both be voted
Okay.
together. Same people.
Adrian Shalom, block 25.12, lot 9, 228 Belmar Avenue, Ocean, bulk variance approval. Is there a positive resolution for the memorialization?
I'll motion for a positive resolution.
Is there a second?
I'll second.
Amy, please call the roll.
Between Jennifer
Yes.
he's gonna get a stay.
Yes.
Ms. Tallarico? You got approved.
Abstain, I wasn't here last meeting.
Mr. Guerrero?
Yes.
Mr. Congeali?
Yes.
Madam Chair.
Yes. The following cases will be carried to October 20th, 2022, to be held in person in the public meeting room, Municipal Building, Deal and Monmouth Roads, Oakhurst, Ashkenazi, Block 11.01, Lot 3, 1036 Norwood Avenue in Ocean, Sean Realty, LLC, Block 141, Lot 3, New Jersey State Highway Route 66, Asbury Avenue, Ocean, Sorora Land Development, Block 22, Lots 85 and 85.01, 280 Norwood Avenue in Ocean, 199 Highwood Road, LLC, Block 25.16, Lot 2, 199 Highwood Road in Ocean, and Seaview Corporate Park for the purpose of scheduling a Zoom meeting which will take place after October 20th, 2022. Okay, the first carried case is the Township of Ocean, Block 159, Lot 1, 100 Cold Indian Springs Road, Ocean, Zone R1. This is an application for a minor subdivision along with a use variance and preliminary site plan approvals with necessary variances. The attorney for the applicant is Martin J. Arbus. Hello, Mr. Arbus.
Good evening. Martin Arbus, Township Attorney for Ocean Township. I also have here, on behalf of the owner, Jen Krimko, who is only going to get up if I mess up, so I expect her up here shortly. You want to introduce yourself?
Good evening, Madam Chair, members of the board. Michael Convery on behalf of Chris and Linda Law, who are noted objectors to this application through a series of correspondence that's been provided to Mr. Kirk. If I can be heard briefly before the matter set to begin, because we did submit correspondence today. I spoke to Mr. Steinberg earlier today, and we submitted correspondence objecting to this meeting going forward on a number of procedural grounds. This letter that I submitted today is dated September 15th. I'd like to mark it as 01 if we could, and then I just want to have some comments. And then I have somebody that is here prepared to testify this evening to the matter going forward. And if I could just briefly, this letter dated September 1st had a two-part. I'm
Just
sorry.
one second. That's going to be marked 01.
I think 01 if you wouldn't mind.
Okay.
And Madam Chair, I was hoping I didn't have to get up this quickly, but we would object to any testimony being put on as to the board's jurisdiction. If Mr. Convery wants to argue the law to you as to jurisdiction, that's fine. You don't have independent hearings with witnesses as to jurisdiction. So I would think that if Mr. Convery wants to make legal arguments and the board wants to make a decision as to jurisdiction, great. But I think it would be inappropriate and not provided for in the municipal land use law to allow I don't even know what the word is in litigation. What is it when you do like a voir dire over the issue of?
Well,
I didn't think you were asking that. I didn't think that you were asking that he be here on this issue. I thought you said you had.
He indicated.
No,
Your planner.
When I spoke to Mr. Steinberg, we submitted this objection this afternoon to the September 15th letter. And the letter is comprised with a memorandum from our planner outlining issues that we believe are the objectionable issues on completeness of the application.
And if I'm not mistaken, Mr. Steinberg, you'll advise the board.
Absolutely.
Number one, there was a question as to the notice
Correct.
that was directed to me last meeting, okay? And I found the notice to be adequate for the purposes of proceeding with the hearing. And that was done on the 18th of August. The notice was appropriate. I understand today part of the noticed information has been withdrawn. the application has any recreational facilities. So we're only here for a D2 variance for the change of the commercial structure to a residential / office, and for a minor subdivision, 2 lots out of 1.
Correct.
Notice clearly covers all that, so the notice is appropriate, number 1. Your second objection, as far as I know from reading the information that you gave me at the last minute, was that you feel that the application is incomplete because there's no site plan.
Correct.
Okay, number 1, for a single-family residence, we don't require site plans in the Township of Ocean. Okay, it's not gonna be a commercial use, it's gonna be residential with a home office, I understand.
Well, Mr. Steinberg, I think that the real issue here is that you can't unring the bell. The fact is that there was a notice provided that had the full extent of the application, which did include the public use. That's the notice that councils relied on. There was never a renoticing of the application. The second thing is that I do believe that the interpretation of the ordinance is incorrect. I do believe that site plan is required, and the reason I do is because simply the way that the site plan reads. This is your own ordinance.
I'm sorry, but may I ask for a 2-minute break to confer with council here,
Okay.
please? There. Okay.
All right.
Thank you. No, we got it. We got it.
Well, it's a reduction.
No, we got it.
It's pre-existing, non-conforming use.
Promise you. But it'll be part of our testimony.
That's not
Got
fair
it.
now.
We got it.
Other
All right.
than- Okay, so your objections so far noted for the record.
Okay.
I
Well, I want
approve-
this marked too, Mark. I'm gonna have it
When
marked.
you get
right?
up here,
Okay.
okay? It's not your case, okay? So how we're gonna follow our usual procedure, okay? Which is, number 1, your objections are noted for the record, and you'll certainly be able to give that. I find that the notice is adequate for these purposes, and that the application is deemed complete. Okay, that's number 1. Number 2, the applicant will present its case. And then you, as the objector or the objector's attorney, certainly have every right to bring your objections as well as your expert to testify.
To the proceeding going forward as
Absolutely.
well at that time. Okay.
Absolutely.
Okay, that's fine.
Back to me?
Yes, sir.
Okay. This is what I thought would be, at this point, a simple application for a minor subdivision and a D2 variance for the expansion of a pre-existing non-conforming use. Most of you know Kepwell Water. It's been around for longer than anybody here. In fact, if you look back over there, there is a picture of Kepwell Water from the early 1900s. So this is a business that's been in existence for a very long time. And for as long as we've all been around, pretty much, the use of this property is going to remain, from the business perspective, exactly the same. The minor subdivision, in fact, is going to eliminate a variance in the sense that you now have a residential structure and the office structure on one lot. So by subdividing and separating that residential structure, you no longer have 2 principal uses on one lot. So that actually eliminates a variance condition. The Kepwell Water Company is going to continue to operate exactly like it operated before. It operated in the location where they are going to continue to operate based on the subdivision. The other portion of the property was used as a residence. And in fact, I think there'll be testimony that the office that's there now had in fact in the past been used as both a residence and an office. So nothing is changing. The only change from anybody's perspective here is they're going to build a little bigger house of 4,500 square feet with the office inside, but the office use, which is the commercial portion, is actually going to be smaller than what is there now. So there are no substantial changes, and everything, for the most part, is going to remain exactly like it is from the commercial perspective. Okay? The other portion is going to remain right now as a home, and that's all that's before this board. Okay? So it's relatively simple. It's a technical variance because you're making the lot that the business is on smaller, but it's still a way oversized lot. So with that, I will bring up Mr. Blash.
If you can state your first and last name,
Gregory Black.
and you will be testifying for, which, expert
Yes,
I'm the engineer.
engineer, okay.
Testified to the subdivision.
And have you testified before this board before?
Yes.
Okay, can you just tell us a little bit about your credentials?
Okay, I'm a licensed professional engineer since 1984, which I don't want to fully admit that for too long, but I've been doing residential site plans and everything for probably about 10 years after I got my license, and I've been a municipal engineer for the last 35 years.
Okay, we'll accept.
okay, and you're the municipal engineer for the Township of Ocean, is
I
that
am.
correct? And on previous applications before the Township, regarding the Township of Ocean, you've appeared before the various boards.
I have.
And your company prepared a plan for the minor subdivision, is that correct?
Yes, we did.
Okay, and that plan is the one that's on the board over there?
Correct.
Okay, and we'd like to mark that as A1.
It's not in the packets, is
Okay.
The same plan was submitted in the back.
Yeah, the plan should be in your packet, and Mr. Blash, please,
it? No.
okay, Mr. Blash, please, can
That's
you
it.
describe,
Yeah, we're gonna hand
Oh,
those
okay,
out
I'm
to the
sorry.
board. The board has not had those in advance.
okay,
No, they won't email.
you emailed them, they're
She's
very
way ahead of
small.
it.
Yeah,
I'm good, I got it.
She emailed them.
Plan?
Yep.
I think so.
Never get it.
Sometimes it's done.
I can pin the statistics.
I don't know what you're gonna say, so just,
Packets and everything.
I said, Mr. Blash, why don't you tell us?
Amy.
Come on. Mr. Blash, why don't you tell us what's going on here?
Okay. Our application before you tonight is for the subdivision of a piece of property located at 100 Cold Indian Springs Road, which is also known as Lot 1, Block 159, shown in the tax maps of Ocean Township. Property is located in the R1 zone district. The property currently, as was described by Mr. Arbus, is the home of the Keppel Water Bottling Company for harvesting and bottling water, as well as the residence for the owners on that property. And I can point these things out to you here.
Yeah, there's a microphone up there, so you can use that.
The existing residence is on the easterly side of the property. You'll see it down in front of the pond. All the existing Keppel bottling buildings and office are up on the east side of the property, all of it having access off of Cold Indian Springs Road. The lot consists of 7.97 acres with approximately 560 feet of frontage on Cold Indian Springs Road. We're proposing to subdivide the property into two lots, which will totally conform to the R1 bulk standards. Proposed lot 1.01 is going to be the larger of the two lots located on the easterly side of the subdivision. Is going to consist of 5 acres with a roadway frontage of approximately 159 feet. Lot 1.02, proposed lot 1.02, will consist of 2.97 acres and will be the remaining property and business operations of the Keppel Bottling Company, as well as what Mr. Arbus had mentioned, the existing office located on the front there, shown on your maps with a little heavier footprint, is going to be where a new structure is built, a 4,500 foot structure, which will be the residence and the new office for the business.
It's going down.
The proposed building will, as was mentioned before, will be the subject of a separate site plan. It has to be submitted for a construction permit to the building department. There are no proposed changes to any parking, any lighting, or anything associated with the Keppel bottling portion of the site, and there are no proposed site plan changes on the piece the township is buying, the 5 acres. The only thing that we are doing that would be considered a minor change is we're eliminating a portion of a driveway which would cross the proposed subdivision line, which is shown as the heavy line, kind of bisecting the property, not in half, but north to south there. Goes through the pond from Cold Indian Springs, goes back through the pond. Okay, with the proposed improvements will also generate less than 2% increase in impervious coverage, right about 2,580 square feet is allowed on this lot here. With the proposed increase in the size of the house, the proposed driveway, which is just the proposal, it's not necessarily going to be what's written in stone there, and the elimination of this, we are right at about 2,500 square feet. So things cannot get any bigger than this, they would only get smaller. So with that, that's why we would request a waiver of any site plan requirement, because we don't ring the bells of the things that would require a minor site plan. We aren't increasing any of the impervious, and we're not increasing any of the parking requirements for the commercial side of this.
Okay, just to say it again and to understand it, what we're suggesting is whenever that is that the current owner decides to build the residential structure with the office, that be a permit application with any, what do you call it, grading plan, whatever, will be submitted to the engineering department at that time.
Correct.
Okay. Okay. That's all the questions I have for the engineer.
Okay. Any questions from the board? Okay.
You have questions?
Yeah, if I could.
Yeah, go ahead. Why don't you go by the microphone up there, Greg, and then you can sit there.
You want to sit? And I'll go up there?
One second, please.
You want to sit and I'll go up there?
Thank you very much.
Greg, I need you by a microphone. We're not picking you up.
Again, Madam Chairman and members of the board, Michael Convery on behalf of Linda and Chris Law. Mr. Blash, can I ask you, you just testified that the building shown on the plans is going to be subject to a separate site plan.
No, it's a
Objection,
separate
that's not what
permit.
he testified.
It requires a grading permit from the township. Any new residential structure requires a grading approval.
So didn't you say that you're going to submit drawings about the 4,500 square foot building that's going to be on the property?
No, I never said that.
So why do you depict it on the plan right now?
That's what we told what the owner of that piece of property would like, a 4,500 square foot structure there.
Okay, so
That's why I said it would only be that size or smaller. It won't be any larger than that.
Okay. No further questions?
Okay, so just to make it clear, what we're showing on there is the footprint of what is proposed for a new structure.
Correct.
And the office use of that new structure is actually less than the current office use.
The office will be located in that new structure, and the square footage of the office will be less than what's currently there now, yes.
Okay.
I just have one follow-up question. Jennifer Krimko on behalf of the owner. Greg, the building footprint is really the only site change in a residential driveway, correct?
Correct.
So the residential driveway accesses the new structure in the entirely opposite side as the office currently functions and will function in the future.
Correct.
So any of the site improvements relative to the commercial use or the non-permitted use that would potentially trigger site plan approval, there are no site changes relative to that. And what I mean is, no parking changes, no lighting changes, no landscape changes, no pavement changes, nothing. The entire site stays the same as it relates to the commercial use.
Correct.
Okay, thanks.
You don't believe that the
Wait, hold on, time
Whoa,
out.
whoa,
Wait
whoa.
till you get up here. You'd hate to miss those gems.
Of course.
They would hate.
So, Mr. Blash, you don't believe that the
Excuse me.
replacement,
Can you get close to the microphone? We just can't pick you up.
you don't believe that the replacement of a larger building than that's there requires any site plan before
by-
this board?
Not per the ordinance.
Are you here to testify to what's being demolished, or is there another witness that's coming here?
Yeah, there's another witness coming.
And who are the other witnesses that are going to testify?
I don't think he necessarily knows, but
Well, can I ask you, Marty?
there will be a planner testifying.
Is there anybody that's going to appear on behalf of Kepwell testify?
No, not tonight.
So there's nothing right now going to be testified to as far as what the current, you made statements on the record as to what's going to maintain and how Kepwell's going to maintain its current normal procedures and operations. Is that your testimony, or is there somebody going to appear from Kepwell to testify to that?
Well, I wasn't sworn in, but the planner will be testifying to that.
He's going to testify to that? Okay. Then I have no further questions for Mr. Black.
Okay, I'd like to call John Takenu. Taikina. You know, it's written right here.
It's phonetic,
How
sir.
it's written. Yeah, I know. Taikina. And I still pronounced it wrong. It's phonetic right there. You should
And
change it.
Mr. Taikina, you are testifying.
You've known me for 30 seconds and you got it right.
You're testifying as the
Planner.
planner. Okay, and have you testified before this board before?
I have not had the pleasure.
Okay. Thank you. Do you affirm to tell the truth, the whole truth?
I do.
Thank you. And can you tell us about your credentials?
Certainly. My name is John Taikina. I'm the principal of all things planning and development in South Brunswick, New Jersey. I've been a licensed planner in the state of New Jersey for 30 years, excuse me. Next month, my anniversary is October 19th, when I got my license. So I've been working continuously since that time as a planner in New Jersey, both for municipalities as well as for private clients. But most of my work is doing exactly this. I testify on behalf of applicants before planning and zoning boards throughout the state, over 100 over my 30-year career. Most recently, Ava and Belmar the other one in Camden County.
We'll accept. Thank you.
Thank you.
Okay, and you've had an opportunity to review this application?
Yes, I have. I have had an opportunity to review the application as well as be at the site and speak to the owner.
Okay. So could you tell the board what your understanding of this application is?
Certainly. So I'm here to talk about kind of the overall of what the application is, and then to talk about what the required findings are for the board to be able to make an affirmative finding in the grant of a D2, what we keep calling a D2 variance, for the expansion of a non-conforming use. So Kepwell, even though it's been here since 1872, the wells have been there longer than that, but operating as a business since 1872, and with the Huxley family since the 1930s, it is a non-conforming use in the R1 district. And that R1 district up down in the wayside area of town really just encompasses what I'd call the Kepwell properties, and then the residential properties that have been developed off of that are located off of the lane, if you will, that kind of wrap around the back. So you have the Kepwell property as it's shown here on A1, and then the lane properties kind of wrap around to the south and to the east. And they're what's included within the R1 district. So it's actually very, very small in the overall footprint of the township. As we said, it is 100 Cold Indian Springs Road. It's 7.97 acres. And we are subdividing, as we said, into two lots. Lot 1.01, that will be 5 acres. It is a fully conforming lot, and it contains a pond, as well as an existing single-family house that will be conveyed to the township. Lot 1.02 is really the guts of the approval, if you will, for the board tonight. And there, we're seeking what's called an expansion of a non-conforming use. And there's a case that actually is specific towards this. So an applicant, Raspberry v. Kingwood up in North Jersey, was just subdividing a piece off of their property. And they had a non-conforming use, and the court said, even if you're doing nothing, by making the lot on which that non-conforming use sits smaller, you needed an expansion of a non-conforming use variance. So that's it, black letter law. So any subdivision making a lot smaller makes it an expansion of a non-conforming use. So that triggers us being here at the zoning board and not at the planning board. From that, the term expansion of a non-conforming use, it doesn't matter how little or how much of an expansion you do, you still need the same approval. And the balancing test, if you will, is a balancing test that's set forth in a case called Coventry, where it said, listen, you're not doing the full use variance arguments here. We have to, prove particular suitability, all those things. The thing the board has to consider is how well does the new site accommodate that expansion of a non-conforming use. So if the applicant were just doing the subdivision and doing nothing else, that'd be a very, very little expansion of a non-conforming use. If the applicant is doing what they're doing and replacing the office structure with an office residence structure, in doing that, that's a somewhat slightly different expansion of a non-conforming use. If the applicant was replacing, the 2,500 square foot office structure that's there with a 10,000 square foot office structure, that would be a bigger impact that you'd have to consider. I would submit to you that we're down on the minor end of that. So we have an applicant that is really just seeking to replace their office use and include a residence within that structure, within the footprint that is shown here on A1. It is a footprint that is fully conforming in terms of its setback and its location. It's fully conforming in terms of its access. And as Mr. Blash said, all the office aspects of it are going to face to the east, and any of the residential aspects are what are going to face out towards the neighborhood. Okay, so it's a residential structure in appearance, residential in scale, and frankly, even at 4,500 square feet, is consistent with the scale and quality of what's been going on in Ocean Township in recent vintage. So nothing that this board hasn't seen before. So we have a D2 variance. So we're going to have to show you two things. We have to show you, one, that expansion is being accommodated on this use, and then two, we have to satisfy what's called the special reasons. So I have to talk about why, what reasons of zoning are we setting forth, and then three, we need to talk about the negative criteria. What are the that we don't have a negative impact on the public good, we don't have a negative impact on the master plan, the zone plan, or the area in general. So, in terms of our special reasons, I would submit to you there are two. Reason G, again, these comes right out of the land use law. You pick them off the list to say which of these purposes of zoning do we satisfy. And I would submit to you that it's G, to provide sufficient space in appropriate locations for a variety of agricultural, residential, recreational, commercial, and industrial uses, and open space, both public and private, according to the respective environmental requirements in order to meet the needs of New Jersey citizens. And secondly, to promote J, to promote the conservation of historic sites and districts, open space, energy resources, and valuable natural resources in the state, and prevent urban sprawl and degradation of the environment through the improper use of land. So in each instance, we're providing sufficient space for this unique use. We have a natural spring water bottling plant. It is actually extraordinarily critical to the family and to Kepwell that that resource is protected. So by placing the 5 acres into public ownership, it just furthers that protection. So here we had a natural resource that was in the private hands that is now being transferred over into the public hands. And we would submit to you that that is certainly a public good. And then secondly, that we are preserving these open space and valuable natural resources. So we are going to have a site that is going to transfer into municipal ownership. That is a good thing, especially in an area of town that does not benefit from a whole lot of public lands. So we think in both instances we satisfy the positive criteria. And then finally, for the negative criteria, can the proposal be granted without substantial detriment to the public good? And does the proposal substantially impair the purpose and intent of the master plan, zone plan, and zoning ordinance? So in terms of the public good, this proposal is for the continuation of an existing business that's been there for 150 years. It's been here before the entire township. Okay? And the minor replacement of the existing office with a slightly larger structure containing the Keppel office and a single residential unit, and the subdivision into the conforming lots so one can be conveyed to the municipality. This isn't a noxious use. We know exactly what's there. Okay? It's been there for 150 years, and someone's been living on the property for that entire time. The building, though it is slightly larger, is residential in scale and appearance, and it's well accommodated again with all of the conforming setbacks and coverages. So you have a lot that's 129,000 square feet. We have a building that's going to occupy, somewhere around, 3 or 4% of that. Very, very small. And as Mr. Blash testified, we're going to have less than a 2% change in the overall impervious coverage of the site. So very, very, very small relative impacts to accommodate this use going forward. And we think that it will do that very well. We think that having a condition that a plot plan or whatever it's called is submitted and reviewed by the township engineer is more than appropriate to make sure that the public's interest and everybody is protected in that instance. And then finally, from a land use standpoint, we don't substantially impair the master plan or the zone plan for this reason. The master plan and its subsequent re-examination reports addresses residential neighborhoods in general with a goal to preserve and maintain the character and value of existing residential neighborhoods, which we believe this proposal does by retaining a long-standing township business, putting, if you will, a new face on it that's consistent in residential scale and character with what's going on in the town, and placing allowing a 5-acre property to go into municipal ownership. The 1990 master plan actually specifically addresses the Kepwell area. So normally, I do get to kind of be a little general with the negative criteria that relates to the master plan. But when the master plan includes a paragraph on your property, you need to look at it a little bit closer. And what it says is this unique character, that this area is being unique to the western wayside area of town. This unique character has advantages and disadvantages. Given the narrow lane that provides access to the residences to the east of the Kepwell bottling plant and the inherent difficulty providing services down the narrow lane. The advantages of this type of subdivision revolve around personal privacy for the occupants, as well as the enjoyment of living in a heavily wooded estate environment. It was recommended that no further subdivisions occur unless the applicant can demonstrate the subdivision will not substantially impact these characteristics of the neighborhood. Big language. So, in this instance, let's look at it specifically. The concern is the narrow lane and how, whoa, come on.
Wasn't in the budget.
Happens all the time, but it had happened to me.
I would help you, but I'm a no.
So, it's concerned about the narrow lane and it doesn't want further subdivision. I would read this down the narrow lane because of the inherent concerns about providing access back there. This subdivision isn't down the narrow lane, okay? It's out on the public street, okay, with conforming width, with good access to everything that's involved. So I would submit to you that we passed the test that this subdivision is not going to substantially impact these characteristics of the neighborhood. We don't create additional lots on the private lane. We're out on the public street. And the introduction of a municipal property will not substantially impact the wooded estate-like characteristics of the area. And this is important. But rather place a significant property in municipal ownership. So the positive characteristics that are cited in the master plan may be enjoyed as a public benefit, but not as a personal private benefit, indeed promoting the public good. Okay, so the master plan was specific. It talks about it, but we address it. It takes, it says, hey, this is a lovely private area, and these people get to enjoy it. We agree, but land use is for the public good. So in this instance, having that property be able to transfer it to municipal purposes, we think satisfies and passes that bar of not having a substantial negative impact on the master plan. And indeed promotes the public good. And finally, we do not expect any site issues. There's more than adequate parking, trash, recycling facilities on that 2.97 acre lot. Their business operates perfectly well. Obviously has its ups and downs over the 150 years. Even over the last 5 years, I'm sure they can tell you. They're in the water business. They bring water. They sell bottled water to office buildings. Where haven't people been in the last 2 years? They haven't been in office buildings. So, it goes up and down, but the business has been operating. It operates very well. It's tucked away in the woods and really doesn't have a negative impact on anybody. And as I said, this new office residence structure is well in keeping with the area and well accommodated in the site. So for these reasons, I think that the board has the ability to make the findings that it needs to, and I'm available for any questions.
And let me just follow up with a couple of questions. It's my turn now.
I'm listening. I'm listening.
Initially, we had also requested a variance for, I think, lot width. In fact, that is not necessary. Is that correct? Wherever you are.
That is correct. The two calls on the site. When you look on A1, you see the dimension of 126.005. That is just for the straight portion of the lot width. There's the second call for the 33.29, which is there, which is a little bit of a radius. You have to add those two together. That's where you get the 159. And again, it was just a typo on the list that it was only
So
listed as
150 is
126.
required, it's 159.
150 is required, it's 159.
In terms of the commercial use, that is, the operation is continuing exactly the same as it is today. Is that correct?
Yes, no changes.
And the commercial use is not generally performed on the lot that is going to the township. There's no part of the commercial use except for the pond discharging to the pond. There's no part of the commercial use that's used on the residential lot.
Correct. There's nothing associated with the commercial use that's on proposed lot 1.01. The pump house, if you will, is where the water is drawn from the spring. It's shown as accessory number 3 on A1. It gets pumped from there, the 100 feet or so, over to accessory building number 1, which is where they bottle it and put it in the bottles, and package it up and then have it ready to go on the trucks. That's done every day, 5 days a week, 8 to 5. Regular office, regular working hours. Sometimes on Saturday when they get busy, I have to come in and do something, just like any other business. But it's typically, regular business hours. Their typical customers are regular business customers.
But whatever it is, that is continuing exactly the same way it does today.
Correct. Exactly as it does today.
And in addition, in terms of benefits, is there also an elimination of a variance because we have two, prime structures on the same lot currently? Two principal structures?
Okay.
I
Yes.
thought I got that from you.
No, it wasn't for me. But
Okay. But we currently have a house and the office.
correct. There are currently multiple structures on this property, multiple principal uses on the property, and they're being consolidated into one.
And in
structure.
terms of the office use with the new structure is actually being reduced in terms of the size.
Yes, slightly.
And do you have any knowledge as to whether that office had also been used residentially in the past?
When you look at it, it clearly was a house at some point, and in speaking with the owner, that it is clearly, and being in the structure, it is clearly set up that upstairs was a house. There's a kitchen and all those things. The ground floor is really set as an office, and then upstairs is just used as additional rooms. So I'm sure it was used residentially at some point in the past. Currently, it is solely used as an office use for Kepwell, and being in there, I would say the office is circa 1963. lots of wood paneling, modern-looking furniture.
I have no further questions.
Okay, questions from the board? Yes, Ms. Talarico?
Hi.
Hi.
I just have a couple questions. So, is this property in a flood zone or not?
No.
Oh, it's not. Okay. That was my next question was about drainage and.
That Mr. Blash would be able to answer any of your drainage questions.
Okay.
The factual question of is it in a flood zone, that I can answer. No.
Okay. And I guess so there'd be no special variance needed to build the new building.
No, it's all encompassed in the one variance.
Okay.
The expansion of the non-conforming use is to shrink the lot, if you will, and then place, and then consolidate, place this new structure as, a office and a residence. That's any, as I said, there's a big range of what that could be, but all of it is encompassed under the one variance, expansion of a non-conforming use, and the standard is, do we have positive criteria? Yes, we talked about special reasons. We talked about the public good. and we don't have a negative impact on the master plan.
Do we know what would be going into that building or not yet?
Yes, it would be kept well, and a home, you know, respectively be used by the owners.
Just to explain, currently the owners live.
Currently, the owners live here.
Right, that's what my understanding
Right.
was.
So they're selling this, and
Okay.
they're going to build a new one there.
Thank you.
Just a follow-up question. So there aren't any outside agency approvals, permits, required pending?
There will be other outside agency permits, I'm sure, but that's typical for the board to, you know, they're with any application.
Excuse me a second, gentlemen. Gentlemen. Okay. We have to hear them. You can have time for your case later.
You know, so I think the typical condition is either get the permit or show me you didn't need it. So that typically how every Mark Steinberg resolution I've ever read has said.
Yeah, Madam Chair,
I'm looking at your report, that's what, okay.
Yeah, I picked up on that.
Okay.
Yeah, any outside agency approval that's necessary would be a condition of.
Okay.
Yeah.
Got it. That was, any other questions from board members? Yeah.
Sir, could you talk to us a little bit about the zone that this property is in? We're talking about dividing, right, the property into two. If rather than dividing it into two, if the folks that own Kepwell decided to sell the entire property, what permitted uses would there be that could possibly go into that area? Would it just be residential? Would it just be a home, and then
the first thing is it could stay exactly as it is.
Right.
So Kepwell can keep going forever, and then it's R1 residential. So, but again, that all on one lot, it carries that restriction. It has what I'll call the Keppel handcuffs on it. When you're not conforming use, anytime you expand, and that's a pretty broad definition, you're coming here.
Yep,
you're a non-conforming use.
And any new owner that wanted to do something other than
this is getting a variance, coming, and they're certainly coming to the board.
Thank you.
I mean, I guess if they anything, because even if they tried to build another house, you can't have two single-family houses on one lot. So even if you wiped Keppel off the map and wanted to put a house there, that would need a variance on one lot or the subdivision. And if you were wiping Keppel off the lot, you're not getting one house. You're getting a lot more than that.
Well, I think, okay, just to stress that point. So if you wipe Keppel off, then this could be subdivided in theory into numerous.
Yes, several. I didn't count. I didn't draw it. It wasn't even a thought. So I didn't draw it. I didn't look at it. But it's 8 acres. It's 8 acres in a 1 acre zone. It has, what do you say, Greg? 593 linear feet of frontage. It's got a lot of frontage. So it could be a couple. That's for sure.
Any other board members' questions? Okay, Mr. Arbus?
Well, I'm not sure if
Well,
council has questions.
When do we want to have a report from our planner?
Yeah.
Oh, I don't know. I thought you did that in the beginning, but.
This would be no, we didn't, because
I know,
we got
usually.
carried away here, we usually do. So we're gonna ask for that, but not to interrupt the flow, why don't you cross-examine him?
Real briefly.
And then we'll present our plans, and then you can present your case in opposition.
Mr. Jim Higgins, reading a whole report.
Thank you. Mr. Takina,
Tykina, please.
Tykina, I'm so sorry.
Okay.
You testified to the Kepwell continued use as not going to change at all. What investigation did you do as far as the current uses at Kepwell?
I've been there on 4 separate occasions in the last 4 weeks. I had an interview with the owner, and I had a visit with the office and operations manager on the site.
Okay. And right now, do you know what the new office and residential building is going to look like?
Yes, a plan was submitted to the town with elevation.
There is a plan submitted?
Yeah.
Okay, and when you went over that, do you know right now how many people are going to work in the building that's to be proposed?
Similar to what it is now, it's been as low as 6 and as many as 12.
So how many people currently work at Kepwell?
At the moment, today, 8.
And how many trucks do they have on the property, do you know?
At the moment, 6. It's been as high as 10 and as low as 2. We are not. We are seeking the continuation of the Kepwell use. The Kepwell use is going to continue to ebb and flow with business as it has for the last 150 years. And it'll go up and down. If they want to add and hire 10 people, they can add and hire 10 people. The Kepwell water use doesn't change. It doesn't change if it's 4 employees, 8 employees, 10 employees, 15 employees. It's Kepwell water. It's a township institution.
Okay. And is there going to be any modification to any of the paved area used for parking or storage at that facility?
No.
Is there any trees going to be removed as a result of this application?
There will probably be trees removed for the residential access driveway around the replacement building. Just stuff that's right against the building.
Do you know who's going to be living in the new residential portion of the new structure to be built?
No.
And do you know if the residents are employees of Kepwell?
No.
Yes, they are.
Okay.
Okay. Thanks, Jen.
I was asked a question. I answered it. You can answer whatever you like.
Jen has to put it to
We can stipulate for the record that the inhabitant of the house will be the owner of Kepwell. It'll be used in association with the Kepwell. It'll be an employee or an owner.
Okay. Do you know of the easement that exists on the property?
The access easement?
Yes.
Yes.
Did you review the terms and conditions of the access easement?
No.
Use? Do you have any? Can you explain to the board what that easement entails?
The easement is a 30-foot right-of-way easement along the southwest portion of the property that comes in off Cold Indian Springs Road and proceeds kind of to the east and provides access to what I called the lane lots 2, 3. I had the list here: 2, 3, 4, 5, and 6.
Okay. Do you know who uses the easement?
I assume the property owners of 2, 3, 4, 5, and 6. I don't believe the proposal has any impact on the easement whatsoever.
Okay. Are you aware of any known contaminants or soil or problems on the property?
I'm not.
Do you know if there are any DEP permits required for this application?
I do not.
Okay. You referenced that there is building plans for the new structure. Do you have them with you?
They were submitted to the township. I actually don't have one physically
Steinberg,
with
do
me.
you have those, or Mr. Arbus, do you have them?
Well, we do have them. They're in our file.
If I could have them marked, are
May I?
you talking? That's the subdivision plan, right?
No.
A1 is the subdivision plan. This
which
is.
is the-
You want to make this A2, the architectural plan?
Why don't you just mark them then?
Do you have an extra copy for Mr. Convery? No? And you can pass one around to the board members if you want to. Right? Thank you.
So referring to A2 for the board, it looks like a house.
Let's just read the caption and who prepared it.
This is new residence business office for Mr. David Huxley, 100 Cold Indian Springs Road, elevations, block 159, lot 102 by Passman and Ercolino, and it is dated 8/3/22.
Do you know what the total floor area is for the replacement building here?
I believe the representation is it will be less than 4,500 square feet. A modest structure on a
And do you
129,000
know the
square
height
foot lot.
of this building?
Conforming less than 35 feet.
And do you know what the current height is for the building that presently exists?
I do not. It is less than 35 feet.
Okay. No further questions, Mr. Buchanan.
Thank you.
Thank you.
You have anything else, Mr. Arbus, before we put
I'd
our...
like to hear.
Yeah, we'd like to- here we go.
Apologize.
Yeah, we jumped the gun with the objection.
The gun.
All right, usual procedure wasn't followed. So, usually Jim goes first.
Jim goes first?
So it's your
Okay,
Jim tonight.
now we're on Jim.
Well, I'm not Jim. I should be sworn in,
I was going to
shouldn't I?
say that's the first thing you're going to
Mr. Ron Reinertson.
Yes.
correct? Okay. Do you affirm to tell the truth, the whole truth?
I do. Ron Reinertson, serving as board planner. I'm employed by CME Associates. I'm a licensed planner since 2005, and my license is in good standing. And pleasure to be here tonight. Hope you accept the credentials.
Yes, thank you.
So very briefly, our report on the planning aspects of it, I just had put in the case law. And Raspberry was touched on, which is saying why the applicant is here for a D2 variance, because the subdivision, the Raspberry case held that it is an intensification of the use. There's also the case of Burbage and Mine Hill, which is mostly associated with D2 variance relief. Now that case in particular was a junkyard, I believe. So this is a much simpler case, I can opine. But one of the interesting things is there that they made a distinction that the enhanced burden of proof, which you often hear about for planning, is not the Medici case, which is focused on variances for new uses rather than an expansion of existing uses. I think the concept is that the Kepwell facility or any non-conforming use has almost a grandfathered interest, a vested right to continue as they do, but they do have to come back if there are modifications. In this case, the modification is simply they are subdividing the lot, so it's not as large as it used to be, and B, and that's really what it is. They're not here for a site plan approval. They're here. They have shown you architectural plans for the building, but that's subject to the testimony's been it's a totally conforming building. The only other thing that they're showing is a plan is an additional driveway, and I would just say, and we didn't really touch on it too much on the planning perspective, but I was out at the site yesterday. It's a very tight turnaround on that site. I would just say that you would look at as part of the Burbage cases. What kind of improvements can you bring to the community? And I would just say that from a safety perspective, I think that'll rationalize separating the residential portion of the access to the site from the Kepwell, and also from the access easement going to the other properties. And then the other thing that the planner touched upon, which I think is pertinent, is in it, as I said in the Medici case, you didn't really have to go to the master plan, but for this particular case, this particular application, it made perfect sense because the 1990 master plan talked about the Kepwell area, and I think this subdivision is in the spirit, I would say, from hearing it, and that's the type of proofs I would want to hear, and I'd advise the board, how does it relate to the area? It's being deeded over to the township for open space. That's the testimony. There's no contemplation of what have you. Yes, the application's been amended. So it's very simplified. Nothing is here before you tonight to talk about the future use of that open space. It's to simply put, Kepwell is going to use one lot, the township will get the other lot, and whatever else is contemplated is for future consideration by the township. So I think you've heard their testimony that about the positive and negative criteria. I leave it up to you to weigh it, but that is, as a planner, that's exactly what I want to hear about. What's the substantial? Is it substantial detriment to the public good, and does it substantially impair the zone plan, and the engineering portion of it? The planner was able to answer, and also the architectural plans. Again, those are concept plans. I think in subdivisions, when you get plans for residences, they're almost like what you call box approvals. It's like, what are you planning? And I think a board wants to know, are you going to build a conforming structure? And I think the representation is yes. It'll conform to all the ordinance height requirements, bulk requirements, setback requirements. And that's to ensure the board that typically maybe a smaller subdivision that someone just comes in and tries to build a bigger house than what was represented. I think that is just another self-assurance that the board can have. So, to me, my part is a little simpler here. I think there are some engineering things that maybe they want to talk about, but the case is really nuts and bolts, subdivision. Talk about the intensification. The testimony has been the operation will continue as is. And when you heard about it, most of the operation is in the area where it's held now. So it almost gets into that category. It's a minimal impact, for a minimal change from what is currently there, and it has been there for 150 years, a long time. So in summary, that's my report.
Thank you, Mr. Matlack.
Thank you, Madam Chair. Yes, the site has been there for quite a long time. You can see it behind the board members up there on the wall. The couple things in my report that were touched on. Stormwater management for the site. The testimony was that there is not really much to be changed with regard to grading. It's just the new structure that you see over there in the rendering, and some driveway improvements. The lot 1.02 will be subject to a grading plan review, which is per the township standards, and that will be reviewed and approved like any normal plot plan.
Ben, please check your mic. They're not receiving you. Okay.
Can you hear me now?
Take the one next to you. How's that?
All right.
You just got to hold the button down. I made sure.
That's okay.
Does that work?
Yeah, that's much
okay.
There we go. Thank you.
Thank you. One thing that I think Ms. Tallarico kind of touched on, and I think I wanted just a little bit more clarification, is the site is not in a flood zone, but I just want some clarification from the applicant's engineer if there has been any historic flooding with regard to the pond on the site, if there have ever been any floods from that, and if the application is to expand the house or the structure. It looks like there's a basement proposed. How is that going to be impacted by the pond? Because it appears to be moving slightly closer. It's still a good distance away, but I just wanted clarification on that. And other than that, there's not much else proposed construction-wise or site work-wise. So the engineering is kind of minimal.
I don't know if I remember the questions in the order. Your first question was with respect to the flooding of the pond. There hasn't been any historical flooding there because most of the drainage area comes from the site itself. Most of the water is generated through the well. So the rainwater is really not a problem. The lower lake on this and on the plans has an outlet control structure that is actually lowered from time to time so that pond at the lower end can be cleaned out from sediment that gets in there. But I don't believe that's been done for many years. But I think 10 years ago, I think Mr. Huxley says the last time he had done that. So there's really not a lot of runoff problems or even sediment problems. As far as the drainage from the house, the structure itself is only going to be about 900 square foot larger than the existing home, which would create de minimis impact of runoff.
And does the house drain towards the street? The property drains towards the street?
That structure drains towards the street as well as the driveway will.
Okay. So there'll be no negative impacts to neighboring properties?
Correct.
Okay.
Or the pond itself.
And can you just talk real quick about the basement? Is there any concern about moving that closer to the pond area?
No, I don't know the exact distance, but it's a pretty good substantial distance from there where that won't have any problem with stability at all.
Okay, thank you.
Could I ask one question based on Ben's questions? So just to follow up on the point that Ben was making, the lots around there, they must be wet pretty much all the time, right? They're. I don't live very close to that area, but I kind of live down the hill. So, just to expand on what Ben was asking, when it comes to flooding, where do we draw the line between flooding and just kind of always damp? Does that make sense?
Yes.
Can you turn it, flip it?
Just to kind of bring it back to the map. Obviously, the pond is the low area in the area. Everything, all of these lots drain down into the pond.
Those go that way? Okay.
Yeah, and I don't know the elevation change there, but it's substantial where the houses up here are not wet.
Okay.
Around the pond is really not that wet because there's probably about a 2 or 3 foot fall in the 10-foot area there into the pond.
Okay.
And everything pretty much drains through. And all this is substantially higher. This house, the existing house on the property, probably sits somewhere in the neighborhood about 3 or 4 feet above that pond elevation. So most of the land around the pond is not marshy. Downstream of this pond, there's a swale that drains out this way. Even all this, there's a wetland area over here. But even up and behind the house, it's pretty much dry.
Okay.
Down to there.
And then as you go east, so that would be east. That's okay.
That gets a little more wetter there.
Okay. Okay. Thank you.
Thank you again, Madam Chair and members of the board. Again, my name is Michael Convery. I represent Linda and Chris Law, who are the owners of 102 Cold Indian Springs. And we had talked earlier in the proceeding about a letter that I wrote today to Ron Kirk. It was copied to Mr. Steinberg and Mr. Arbus. And I'd like to mark this as 01.
Any objection, Mr. Arbus?
No.
And I just want to say for the record that we had a two parts to this letter were really based upon the fact that, and one of them I just want to get rid of, which is the fact that we initially didn't think that Mr. Steck was going to be available this evening because he had an appearance in Mawa. So a portion of this 01 exhibit is based upon the fact that Mr. Steck was not going to be available, and we wanted to be able to have him testify tonight. So you could disregard the portions that deal with his unavailability, and the remaining portion deals with the issues concerning whether or not there was completeness in the application, whether or not there was a defect in the notice, and whether or not this application, whether the board had jurisdiction to proceed tonight. And Mr. Steck's here to testify to that. So we'll begin with him. And on this 01 exhibit, I just want to say that there was a memorandum prepared by him as a part of as 01, and he's going to testify to that first, and then he'll testify subsequent to that to the issues concerning the intensification of the non-conforming use.
Okay. Mr. Steck, can you state your first and last name?
Peter G. Steck, S-T-E-C-K.
Okay, and can you raise your right hand? Do you affirm to tell the truth, the whole truth?
I do.
Okay.
Mr. Steck, if you could, before the board, just outline your qualifications for your appearance tonight.
Yes, by way of education, I have a bachelor's degree in civil engineering and a master's in city and regional planning. I'm licensed as a planner in planner number 1776 that I received in 1976, and the license is still in effect today. In terms of experience, I've worked with a couple consulting agencies. One of them was Alvin Gershon Associates, and I actually worked on a master plan for Ocean Township more years ago than I can remember. I also was the planning director for the Township of Montclair for just under 10 years. I was a planning associate with Malcolm Kassler Associates in northern New Jersey, and I've testified in approximately 200 municipalities in New Jersey and been accepted as an expert planning witness in those jurisdictions as well as in Superior Court and Tax Court.
Madam Chair, if I could ask you to accept his qualifications this evening.
Any objection, Mr. Arbus?
No.
Thank you. Mr. Steck, you had an opportunity to review the application,
Yes,
and have you gone to the site?
I have.
And did you review the applicant's file that was on file at the township?
I did.
Okay. And so you're fully familiar with the application this evening?
I am.
And you're also familiar with the documentation that's been submitted in support of the application?
Yes, as well as the testimony that was presented this evening.
Okay. And did you review the application for completeness when you went to the town?
Yes.
Okay. And when did you go to the town?
It was last Friday.
Okay. And at that point in time, did Mr. Kirk make available to you the entire file for tonight?
Yes,
Okay. And you had an opportunity to review it?
that's correct.
All right. And if you would please testify as to what it is that the nature of the application this evening.
Right. The first thing I'm going to talk about, and then I'm going to return to the substance of it, but as you recall, there was an issue about the adequacy of notice, and I had done some research on that, and the board has proceeded despite, at least on the surface, an objection about the adequacy of the notice. But I want to raise, at least from a planning perspective, issues about the notice. The published notice talks about a minor subdivision. It does not talk about site plan approval. And the published notice talks about not only the subdivision to produce a new lot for ownership by the township, but it talked about what that lot was going to be used for. And the early rendition of the plan said there's going to be a play area. There were notations on a plan to that effect, but partway through the game, the application process, the applicant withdrew the proposed use of the new lot that's proposed for public use. We learned this evening that there's a D2 variance involved. There was one D2 variance noticed in the public notice, which had to do with the fact that the Kepwell business is going to be on a smaller lot. There is also an issue that I'll raise about the driveways on the property. So let me suggest that while the applicant has pulled back the application in terms of what's being requested, the proposed use of the proposed easterly publicly owned lot is significant and important. And just because the applicant says, we're only subdividing this for public ownership, I don't know who's going to live in the new dwelling that the town will own, but because they are now silent on what it's used for, while the applicant, in my opinion, the original application needed a use variance because public recreational use is not a permitted use in the zone.
You know, I'm going to object to this testimony when that is not before this board. That part of the application, whether he's right or wrong, we think he's wrong, doesn't matter. That part of the application was withdrawn, it's not before the board, and it is irrelevant.
Okay, being you object and your objections noted for the record, I have previously determined that the notice was adequate for these purposes, but I assume you're making a record,
I am.
so let him continue.
So the
Just
nature,
let me say, with all due respect, he sent a letter that is now D1. Or
Well, the
whatever.
board is, yeah, well,
That's a part of the record, so I don't know if we have to hear it again, but okay.
If I could suggest also, if the applicant wanted to withdraw the application and resubmit and renotice, they could have done that. The fact is that, again, you can't unring the bell. The application is based upon a notice that includes the intended use of the public portion of the property. So while it's safe to say that they withdrew the application, it's not before the board. The notice that is before the board includes those uses. So I think that they could be spoken to.
With all due respect, bells are rung all the time.
as I said, I
People
find that,
reduce.
look, I'm the final determinant.
He is, I agree with Mark.
determination concerning the notice. I find the notice adequate for tonight to proceed for this application. You're welcome to make a record, and you feel that I'm wrong, continue.
Okay.
But it's all written already in your report that's being submitted to the board, which will then go to a court if you choose to do so.
The elements of this application that I believe should be in a public notice, it's clear that this is a minor subdivision. We have a big lot, we're dividing it into 2 lots. The applicant has acknowledged that there is a intensification of the Kepwell use, because while it was on a very large lot, the lot is being significantly reduced in area. Part of that, there was a reference to this Raspberries case. In the Raspberries case, there was a non-conforming 2-family house. No change to the house. They were just taking vacant land off of it. And the court said that's a D2 variance that has to be addressed. In this case, they're not only taking land away from it, but they're expanding a building on the property. They're demolishing one building, putting up a larger building. I'll talk more about that later. In my opinion, this application requires site plan approval. And the facts associated, while the applicant says, we'll come back later for site plan approval.
No, that's not what he said.
Okay. Well, the record will reflect what the witness said. But in my opinion, this requires site plan approval. You have a non-conforming use today where someone's demolishing an office building on the property and putting up a larger building that's taller and bigger. We don't know much, as you saw from the witness, about what the dimensions of the existing building are, but it's going to be demolished. There's a bigger building put there, and while the applicant is phrasing it as, oh, a residence with a home office, this is not a home office. This is the office for the Kepwell business. That's not a home application. This is not simply someone building a single-family home on a separate lot, and in my opinion, it requires site plan approval. And that's inherent, in my opinion, to the board wanting to understand whether the statutory criteria are met for the so-called D2 variance. Not referenced in the notice is the fact that on this property, by easement, there is a driveway that accesses, I think, 3 other homes that are not on the property. That driveway is not an accessory use, because an accessory use has to be on the same property as the principal use. So you have a house, you have a driveway, the driveway is clearly permitted accessory. But this is a driveway that accesses principal uses off of the property. That driveway is not a permitted use in this zone. It is a second principal use, and it is being intensified in the same way that the Kepwell business is intensified, because the land that, in a sense, is part of the buffering is being removed. So, in my opinion, the notice is inadequate because it doesn't acknowledge that site plan approval is needed. It doesn't acknowledge the second D2 variance, which has to do with the driveways, the access way that's not accessory to the building. The other issue that I'll spend a little time on is the applicant, in a sense, cleaned up the application by saying, okay, we're not going to tell you what the public use is going to be of the easterly lot. It's just going to be, it's subdivided, it's going to be owned by the town. So in one sense, that slate is clean. We don't know what the use is going to be for that public lot. It might be a commuter parking lot. It might be a site for a beach. It might be a site for festivals. Because you don't know what that lot is going to be used for, I don't think the applicant can say, oh, no problem, it's open space, everyone will be happy. Well, you don't know what the use is going to be, so you can't have it both ways. You can't say, I'm not going to tell you what that new lot is going to be used for, and at the same time say, oh, this is a wonderful public benefit. I want to get in, so my conclusion, at least from a planning point of view, is the public notice is inadequate. Now I want to address the testimony presented by the application, the applicant's witnesses.
I don't know if the first part requires any response, Mr. Arbus, by anybody?
With all due respect, I mean, frankly, I think you've already ruled on it. I think the public notice was proper. As I said, people unring the bell all the time. You make changes to the application as it's pending. There's nothing wrong with that, nothing unusual about that. And the fact is that right now, the 5-acre piece is going to be owned by the township. What it's going to be used for in the future will be determined at some later date. But the bottom line is it's currently a residential use, and I think that's all that has to be considered at this point.
Okay. As I analyze this application, the applicant is saying, we're tearing down an office building. It might have at one time been used as a residence. There's no evidence. It would seem to me that the residential use had been abandoned on that. It has been used as an office. The applicant is saying, I'm replacing this with a single-family house, a new dwelling that's going to be bigger, in a slightly different place. It will involve changes to the driveways. This is not a simple single-family house on a lot where you live. This is a new building on a non-conforming use that is not just a residence. It has offices associated with the kept well activity. In my opinion, a plain reading of your ordinance says that this requires site plan approval. And while that's the procedure to get this approved, in my opinion, you need the site plan details to judge whether the D2 variance can be granted. The applicant says, oh, it's less than 2% impervious coverage. Well, where is that? It's not on the plans. We don't know those details. Is there going to be some kind of landscaping? There are going to be trees removed? Is there going to be landscaping in front of the house? All of the things that you normally look at in site plan approval are not here because the applicant is saying, oh, we don't need site approval. Well, I disagree. And I think it's an inherent part of the application that you need to know to judge whether the statutory proofs are satisfied. It is interesting. So the applicant suggests that, and this is, I agree, it's not a Medici case. There's already an impact in the area because there are trucks here. This is a commercial use. This is not a public use on the property today. The applicant was suggesting that two purposes of the municipal land use law were advanced. One was having sufficient space in an appropriate location, if I recall. And then there was, I think it was G and J. G talked about sufficient space in an appropriate location, and J talked about preserving open space. You don't know this evening what the public lot is going to be used for. It's going to be publicly owned. That's all you know. It might be a commuter parking lot. It might be a public works garage. The applicant is not telling you. Yet the applicant is saying it's a wonderful public benefit that the town owns this property. But you just don't know what that ownership will result in. To talk about sufficient space in an appropriate location, apparently there are problems with the existing operation here because of the driveways, and that was referenced in the master plan. The master plan said it's great that this non-conforming use in a residential zone that only permits essentially single-family homes, it's great that it has all this open land next to it because it acts as a buffer. And that buffer is going to be removed. Let me repeat what was in the master plan, because while the applicant believes that it's supportive of the application, in my opinion, it suggests caution. So this is from page 147 of the 1990 master plan. And it's 3 paragraphs I want to read. The second distinctive area within Western Wayside is a unique residential area surrounding the Kepwell Springs water bottling plant at the intersection of Cold Indian Spring Road and Bound Road. This area is unique in that it is served by a narrow private road, period. Lots, which are irregular in shape, all exceed 1 acre in size. The area at one time was one large lot, which was subdivided piece by piece over a period of years. The unique character of this area has both advantages and disadvantages. The disadvantages exist with regard to the provision of public services, including fire and first aid response, garbage collection, and police protection. The width of the access road and the solitary nature of the lots create problems for the provision of these services. The advantages of this type of subdivision revolve around personal privacy for the occupants, as well as the enjoyment of living in a heavily wooded estate-type environment. It is recommended that no further subdivision of this area be permitted unless the applicant can demonstrate that the subdivision will not substantially impact these characteristics of the neighborhood. So there are positives and negatives here. The master plan recognized that there's some traffic issues with emergency access and the driveway here. The applicant is not remedying any of that. In fact, it is reducing the lot area, so you have less flexibility to remedy those problems that were identified in the 1990 master plan. So, in my opinion, first of all, these purposes that were sought to be advanced are not really being advanced by the applicant. The applicant says under G, sufficient space in an appropriate location. Well, apparently there's not sufficient space today to accommodate good, efficient, safe traffic patterns. The master plan says that. Then the applicant says, this is great because we're going to create open space. Well, the open space is certainly not on the Kepwell property. That's getting more intensified. The open space that the applicant is talking about is the lot that's going to be owned by the township. And we don't know this evening what the township is going to do with it. It initially was an application that says we're going to have a park here with not many details, but there were some details. Those are removed from the plan. So, in my opinion, the applicant can't say that this open space is great for the neighborhood and the public without identifying what the use is. Again, this could be a commuter parking lot. Who knows what it is? It could be a public works, could be a police station. We don't know what the use is going to be. And that's why, in my opinion, the use of that lot is essential to judge whether the master plan is substantially impaired or not. Because the master plan said there are pluses and minuses to all this open space. And the answer is that without knowing what that open space is going to be used for, you can't, in my opinion, say that this will not substantially impair the intent and purpose of the zone plan and zoning ordinance. So, in summary, the two purposes that are alleged to be advanced, the one talks about sufficient space in an appropriate location. There is a reduction in space in an area that already is known to have traffic and accessibility problems. Number two, what open space? Just because the public owns it doesn't mean it's open space. We're sitting in open space this evening in the municipal building. I mean, we're sitting, wait a minute, in a publicly owned property, but not necessarily open space. And what I'm suggesting is that in order for the applicant to validly demonstrate satisfaction of the statutory criteria, that there is no detriment to the public good, that's like access for emergency firefighting equipment, or no impairment to the zone plan and zoning ordinance, preservation of the neighborhood and estate type character. In order to make that judgment, you need to know what that new lot is going to be used for. The applicant has the perfect right to say, I'm not asking for any use for that property. He has the perfect right to do that, but they suffer from doing that because now you don't have a basis to conclude that this is not substantially detrimental to the master plan. So I don't, in my opinion, there is insufficient information. Your code requires a site plan application for this, and that would help you make these judgments. Do we rework the driveways so it's safer, so we can get emergency vehicles there? The master plan says there's a trouble. How do we remedy that? The applicant is not remedying that. In fact, it's making it more difficult to do it. So in my opinion, the applicant, by its own choosing, has handicapped itself in terms of the proofs that it needs. And as the record stands this evening, I do not believe that there is enough evidence to support an approval of this application and to meet the statutory criterion.
Okay, done? Okay, now before I turn this over to Jen Krumko, I just want to say, I don't think it's going to be used for commuter parking lot. I want to make sure that everybody understands.
First, before Jen, does the board have any questions of the planner?
You.
Okay, so, Mr. Steinberg, I just want to make sure, as far as the public notice for inadequate timing, the driveways, I can't even find the other one. I just want to make sure you have reviewed it.
Yes,
and you
I've reviewed it
believe
several
that-
times prior to the 18th of August and prior to tonight's hearing. What the applicant plans to do is adequately noticed. Okay? Notices don't have to be 100% of everything you want to do. There's certainly enough information contained in that notice to give the public the feeling of what's going on, and they can certainly explore it further, which is why you say that the plans are available in the municipal building. The notice is adequate, in my opinion.
Then, Mr. Reiner.
I'm not sure that needs, I don't believe it needs site plan, and I don't believe that there's a secondary D2 use because of the easement.
Okay, so that was going to be my question, Mr. Reinertson and Mr. Matlack. So, as far as the site plan and, sorry, it's a little small on my screen here, but
The other thing would be, I think he says there's a
the
D2.
accessories and
Yeah,
the
D2 for the easement.
the D2, is that information required in your professional opinion? Do you have concerns about it not being provided?
I think that it would be turning logic on its head to talk about an accessory, an easement for a driveway that's granted for the benefit of people off the site as a principal use. That's an agreement that was granted probably decades ago. It sounds like these was divided off the original Ketwell property. So it sounds like that's not going to change. So I can't see that being a second D2 use. But I think on the notice standpoint, I defer to my legal colleagues. But I just kind of look at a logic as this: did the notice give adequate an adequate picture to the public? It noticed that it's a D2. We can quibble about it. It's one D2, two D2s. People knew it's a D2. It's an expansion of a non-conforming use. And I just want to put one point and just reemphasize the D2 case of Burbage, as I mentioned previously, it's differentiated from the D2 where it's a use variance, where that it had to have the enhanced proofs of the master plan to see if it comports with the master plan. I think the logic is a D2 use is vested. It's been here longer than the master plan, so it's almost grandfathered in. So I think that Mrs. Tech makes a valuable a valid point in talking about it, but I think the applicant's planner also mentioned it, and I emphasized that that's information above and beyond that he offered to support it. It's not something that would hinge, you're really dealing with the positive and negative criteria. That enhanced burden of proof is not applicable to a D2.
Okay. And Mr. Matlick, do you have any other comments?
No, I don't
About
have
the testimony.
anything to add other than what my colleague just said.
Okay. Ms. Tallarico and then Mr. Fuller?
I just had a question about the driveway. Is there enough access if the open space becomes, I don't know, not a parking lot, but whatever it becomes? Is the driveway, it's connected, right, to that second?
On behalf
Okay,
of
Jen, we need a microphone also. Jen, we need a microphone.
I just don't understand, like,
I know.
Absolutely.
how you get access to that property?
Perfect.
Okay.
Perfect. So let's talk about the subject property first. Lot 1.01 is the 5 acres that's proposed for municipal ownership. It has 150 feet of frontage on a street, on a public street. And it has a little U-shaped driveway that's going to be relocated fully on its lot. So you have full turnaround there. And then you have a driveway that goes back to the house. And you have a little parking area in front of the, a little area in front of it to be able to access the house. This is a separate driveway off of a public street. Doesn't impact anything, any future use that the township, and again, for the township, it is generally accepted that the township is going to act in the public good. Okay? We don't think the township is going to do bad things. Okay? So, others have the uncertainty that, big, bad, evil things could be lurking out there.
But
They're
I
not.
also have a question about.
So the direct access is for lot 1.01 is off of a public street called Indian Springs Road. The access for Kepwell is also off Cold Indian Springs Road with multiple access points. One is being removed, and the remainders will be more than adequate. The lane that is referenced in the master plan is the lane, the 30-foot right-of-way easement that runs down the southerly side of the property and continues off to the east and provides access to Mr. Steck's clients on lot 3. And so that is the access that's restricted, that has problems with garbage trucks, that has problems with emergency services. That's to the off-site homes that has zero impact on what goes on. This application has no impact on that whatsoever. Now, the suggestion that this could be improved somehow, if you had site plan, is that you need site plan to improve it. Trust me, if Mr. Matlack had a circulation concern on the plan, if Mr. Blash had a circulation concern, because he's a municipal engineer at heart, if they had a circulation concern on the site, including access to residential homes, Mr. Matlack certainly would have. I know Mr. Blash would have raised it. Mr. Matlack certainly would have raised it. Okay, those concerns just do not exist. The concern expressed in the master plan relates to the access on the lane. It says don't do further subdivisions, that impact the lane. We're not proposing a subdivision that impacts the lane. We're proposing a subdivision to provide for municipal use on Cold Indian Springs Road.
Does that answer your question?
It does. I just have one extra question. I'm sorry.
Oh,
so
great.
You're saying from that second piece, when you separate it, they would be driving out that second driveway, not the easement, or they would be driving out both.
No. The new municipal lot
Yes.
only goes on that lot's driveway to Cold Indian Springs Road.
So
Period.
It wouldn't be going.
No, it is
over
hundreds of feet.
For lot 3.
No, hundreds of feet away. So the driveway is up at the northern side of the property, and that is all the way down at the bottom of the property, you know, in excess of 250 plus 200, you know, 400, hundreds, let's leave it at hundreds of feet away.
Understood.
Can I just
Absolutely.
It's the same question along the same lines of the easement. There's currently a road that or a driveway that branches off the easement between the new proposed building and the masonry garage. Is that currently being utilized?
Yes.
What is it utilized for?
You can drive in there. The trucks can circulate in and out of that driveway. Come around to get to the office. You can come in there and pick up water, and then you can either come back out that driveway or you can go around and go out the driveways up to the north.
So the new proposed driveway that's, I'll say, to the Cold Indian Springs side of the proposed building just provides another way of getting around this. You're essentially creating 360 access around the property now?
Correct. And again, that's going to be solely the residential driveway, and that's the aspect that'll be subject to the to be subject to a plot plan that's reviewed when that structure is reviewed. But again, as Mr. Renderson said, the references, and he said, on a subdivision, you've seen subdivision plans and they approve little boxes. And the implication is that we're going to provide a conforming structure here. It's going to meet all the setbacks, it's going to have all the right buffers, it's going to have all the right landscaping, it's going to have all those types of things.
Can we do a favor? Can we take a 5-minute break? I think everyone needs a 5-minute break.
Can Mr. Fuller just ask his question? And then
Sure.
I've got 2 hours of questions. I'm just kidding.
You can tell I like the question.
Just to, I want to refresh my memory. Did the applicant testify that lot 1.01 will be used for open space?
No.
Will it be preserved?
I said it will be used. It will be conveyed to the municipality. That's it. I have no idea. I have no idea how they're. I don't know what funds they're using to buy it. I don't know any of that. It's being conveyed to the municipality. Period. What the municipality does with it is up to the municipality.
Right now, it's a house on 5 acres.
Can I ask a question about that? And whatever the town chooses to, if they want to change the use of that property, they would need to come before the board, correct?
They would need to go before some board.
As a capital review.
As a capital review, right.
Correct.
So that'd be subject to another approval process.
It would have to be a capital
Right.
review.
So right now, it can only be used as a home pending some other approval.
And just to stipulate
Thank
one
you.
thing for the record, Mr. Huxley, in the contract to sell it, has the right to live there for 6 months after closing. So for at least 6 months after closing, it will remain a single-family home, because Mr. Huxley has the right to live there.
That's correct.
Okay, 5-minute break.
Please.
We'll return at
Back in.
9:30.
You got it.
Good evening. We're going to begin. Amy, will you please call the roll?
Here.
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 Here. Okay, Mr. Convery, did you have any other witness?
Well, I just think. Did you cross-examine Mr. Stack?
I have no questions for Mr.
And Ms. Krimko?
If you wouldn't mind, if I could have Mr.
Oh,
Steck.
before cross-examination.
Yeah, just
Okay.
speak to the issues that the
Okay.
This is just as the last testimony that was offered. As the board knows, it's the burden of the applicant to prove its case. And to say that, if there was a problem, our staff would, trust our staff, they're all going to bring it up. Good staff, the answer is it's the burden of the applicant to make the proofs. The reason a site plan is, in my opinion, not only required but needed for you to make the judgment is that you look at this and you don't know where trucks are parked. You don't know where employees' cars are parked. They're not on the plan. Potentially, rather than putting a house in the middle of all the traffic. Okay. Should I repeat what I said? First of all, it's the burden of the applicant to demonstrate that it deserves the variance relief that's being sought. And to say that, well, if there are any other problems, our staff, the municipal staff would clearly have picked it up and brought it to your attention. I repeat that it's the burden of the applicant to demonstrate that it has been met. The applicant says no site plan approval is required, but in my opinion, it is required, just a plain reading of your ordinance, number one. And again, this is not a single family house, number one. It's got a corporate office in it. And it's on a non-conforming site. So if someone put a single family house in the middle of a parking lot in a shopping center, would that be exempt from site plan approval? I don't think so. If this house were put in a different location, it might be advantageous to rework the access here so there's less confusing. You don't even know where cars are parked on this plan. You don't know that there's a concrete structure on the east end of the pond that might be classified by the state as a dam. None of this is on the plan, and in my opinion, those types of details are important for you to make a judgment. And without that information, you're losing an opportunity to fix this site.
We have to.
Couple things. Currently, the site is used for a house and the business and the office. We're not introducing any new uses, correct?
That's correct.
Okay. And all of the buildings and all of the driveways and operations relative to the commercial use, you heard the testimony and I think the plans speak for themselves. You keep insisting you want a site plan, but does this plan show all the buildings existing and proposed?
It shows the existing buildings, but the notation as to proposed, it says, if I can answer your question?
It was a yes or no question.
I can't answer it yes or no. I want to read what's on the plan.
I think the plan speaks for itself. We've taken up enough time. So again, all the existing buildings are shown, and it's showing the location of the new footprint of a building.
It shows a new location of a building, but without a floor plan, for example.
Okay, but it's not a new location. It is exactly over the existing
That's
office.
not correct. It's bigger than the existing building. It's taller than the existing building.
Sir, you're conflating the issues here. I said, is it over the existing footprint? I didn't say it wasn't bigger. There was testimony it was 900 square feet bigger.
Parts of it are over the existing footprint because it's bigger. It extends more than the existing
We all
building.
understand that 900 square feet.
If you let me finish, I'll finish and
Okay,
try to
then-
accurately answer your
Shut it down.
question.
Here's my next question. Is the building in any
Put it
way
down.
going over any existing parking?
We don't know because the site plan does not show where the parking is.
Okay, let me rephrase that then. Are you assuming then that people are parking on grass, sir?
I think some trucks do park on grass.
Yes.
Is there any building going over the existing paved areas?
You can't tell from this plan. I think it may or may not. You can't tell because it's not drafted as a site plan.
Well, I respectfully disagree, and I think the board can see where all the driveways are.
Let's
Okay.
just limit it to questions.
You heard the testimony as to the operations. Are any of the current business operations, based on the testimony and the fact that the only driveway is to the house, do any of the business operations currently occupy the 5 acres where, do you have any evidence that there are any business operations?
There's no testimony about what operations currently occur in the house other than the owner lives there.
Correct, so again,
There's no testimony one way or another.
Tykina, so you missed Mr. Tykina testifying that this was only used for the single-family home and all business operations were on the lot?
There's a proposal that way, but I don't think there's any evidence. The evidence is that the owner lives in the house by the pond.
Correct, single-family home by the pond. So if the entirety of all of the operation, let's assume the entirety of all the operations occur where the existing buildings and existing pavement are.
Let him sum up
And we're
first.
drawing a line. While it's technically a use variance under Raspberry, are we changing the operations in any way?
You're changing the buffering that exists now that insulates this commercial use from some of the residential uses in the area.
Which residential uses are less buffered now?
All of the uses that surround the property are being buffered by that single-family home and pond.
Okay, so again, you're conflating issues. The proofs you're giving and the argument that we're not meeting the proofs have to do with the subdivision and the ultimate use of this piece of property. However, this piece of property is the only one that needs a conditional use variance. So again, by limiting the size of the lot upon which this operates, what negative impact are we having to the surrounding neighborhood? Forget about this lot. It's gonna be a permitted use.
We don't know that it's a
You
permitted
don't
use.
have to know, it's not part of the conditional use standards. Again, by shrinking this lot, what business operations will now have a negative impact where they wouldn't before?
The placement of the new house may change the traffic flow, may change the parking arrangement. We don't know because the plan does not reveal those details.
Well, we do know because the plan shows the driveway and the parking for the house and shows the parking.
That's
for the
his
business
answer.
on top.
Okay, can we
But
please
that's
question
his
and
answer.
answer?
He doesn't
No,
know.
this is
Okay.
beyond.
Mr. Arbus, do you have any questions, Mr.
No, I
Stone?
have no questions. Done?
Does the objector want to offer any other witnesses?
No other witnesses, Mr. Steinberg.
And your case is concluded? Okay. So now we do summation, which is
Does the
you.
public have any questions?
Right, forgot that one. Public.
Questions or comments from the public?
Right.
Public wants it over.
Seeing none?
None.
Okay, Mr. Arbus?
Do we go with him first?
Yes.
Oh, I'm sorry.
You know, Madam Chair, members of the board, I feel very confident with the testimony that Mr. Stex offered. I mean, you have to make a decision based upon what you heard tonight, whether you have enough in front of you to determine that there's not going to be a substantial detriment. The first witness went over the criteria for you to make that determination, and if you believe that everything that's been put before you gives you that right to say, yes, we believe it's not going to be a detriment to the public good, then you have the right to vote on that. We raised issues concerning the notice. We raised issues concerning the information that you've been provided. We think that a site plan is necessary with respect to you being able to say, yeah, this is not going to be a problem. And they had the intention early on. This is a contract purchaser. They have conditions in the contract on approvals. They noticed this early on in August. They could have changed their notice. They could have taken everything and reapplied, but they did what they did. They reduced the application. And in doing so, you know, the things that you know the intended use to be are already in front of you. And by taking this application and say it's just about a subdivision and an intensification of a use, it's really not giving you the information that you need to be able to make the qualified determination that the D2 variance requires. And I think Mr. Steck said it, and I think that the witnesses have not had enough testimony before you to talk about the use. They say the use is not going to be changed, it's not going to continue. There was nobody here from Kepwell this evening to affirmatively put that before the board. You had the planner speaking to those issues, but in the full conclusion, in order to grant the D2 variance, you have to ensure that there's not going to be a substantial detriment, and we just don't believe you have the evidence in front of you to do so. Thank you.
Mm-hmm.
Everything you said is wrong. This is a simple subdivision at this point. One lot has a house on 5 acres. It's going to be owned by the township. The other has the same exact business that has been at that site forever. operating in on the same piece of property, the same section of the property that it is going to retain and that it has always operated its business from. Nothing is changing except the 4,500 square foot building, which is over the existing structure. So someone testified it was 900 feet more, but if you look at the plan, it's directly over the existing structure, and that structure's there. It's on the same spot. Both your experts, our experts, your attorney says this doesn't need a site plan. It's a house. It requires a grading plan so that if there's any issues, that'll be dealt with with a grading plan and a permit. And frankly, to me, again, as I said in the beginning, it's a very simple application for a minor subdivision and for the D2 for the expansion of a pre-existing non-conforming use that is really technical in nature. Thank you.
Very, very briefly, Madam Chair. I think that the most important fact here is the only negative impact that the objectors have been able to come up with is what the potential use of the municipal lot is. And that just isn't before you.
We need a microphone, please.
The testimony of Mr. Steck squarely focused only on the negative impact of the potential municipal use on the municipal lot. He was unable to identify a single negative impact by the reduction of the lot from where Kepwell is. If the board is concerned of any potential change that would trigger site plan approval, then my suggestion is that if you're going to grant this, grant it subject to no site changes being made with regard to the operation of the existing Kepwell business. What that means is if they change parking lots, if they change driveways, if they change lighting, if they change landscaping, anything that would otherwise trigger site plan approval would require them to come back. But if the only changes are replacing the building and expanding further away from where the business use is and putting in a residential driveway, there's nothing that would trigger site plan approval. So to the extent that you don't trust your professionals, I know that you do, but to the extent you don't, as Mr. Steck suggested, that they didn't catch everything, if you put in a condition that the site operations can't change physically over what they do today, then you've addressed that. And when it comes to the negative criteria and the harping about the negative impact of granting this conditional use variance, that's not where the negative impact comes from, according to the objectors. The negative impact would be that the township owns the lot and they might do something in the future with it that will have a negative impact. The municipal land use law has regulations for how a municipality can govern, can develop land. They're going to have to go through that process. The only thing before you tonight is, one, is it a fully conforming subdivision? Yes. Two, can the reduced site where the Kepwell is continue to accommodate the use without having a negative impact? And the answer is yes. There's been no evidence to the contrary. So based on all of the above, I'd ask that you vote in favor and condition it on no site changes other than what's depicted on the plan, and on submitting a grading and drainage plan for the township engineer's review at the time of construction of any structure and driveway. Thank you.
Want to know what?
Yeah, go.
I was going to ask with Mr. Matlack's report, I thought 6E covered any conditions if the board wants to approve it. If I'm not.
What number?
That's the outside.
Oh, that's all the outside agency's approval.
I
The
thought that
applicant-
was standard if the board
That's
chooses.
the standard. That's been stipulated to. In addition to that, Ms. Grimko, I assume on behalf of the applicant?
Well, again, that portion of the property impacts her client, so.
Right, so she has offered that in addition to that, there'd be a condition that there be no site changes to the physical operation.
If the board wants that,
You know,
she
to the
says she's
physical
okay with
operation
that.
without having to come before the board, this board or another board, for site plan approval, other than the replacement of the house that's 900 square feet larger and the residential driveway. Now, this subdivision does include the change in the change in the existing driveway, which is now crosses over the line. That's going to be eliminated. So that is another change. That's in the top corner. on Coldinian Springs, there's a part of the driveway turnaround that overlaps the two lots, and that's going to be removed.
Okay.
Okay.
Just,
So
just to clarify, that,
Okay.
just to clarify, that's the driveway accessing the existing residence.
right, and that portion of that
the
driveway that's on the new lot 1.02 will be removed. So other than what they've shown on this plan, if they do anything else, change the parking lots, change the lighting, change the landscaping, whatever, well, within reason, then they'd have to come back to a board for a site plan approval. That's a condition that we can put in. Basically, they got two things here, okay? The only reason that this board has jurisdiction for a subdivision, which is usually a planning board jurisdiction, is in conjunction with a D variance, okay? So I guess you have to decide the D2 variance almost first before you can decide the site plan. And then the site plan is a fully conforming
Subdivision, not
you're right. Excuse me. Subdivision. The subdivision that's before you is a fully conforming subdivision. It is a minor subdivision. It meets all the criteria of a minor subdivision. The lots are more than big enough for what remains, okay? And everything is okay for that subdivision. It would be passed without variances in front of the planning board, 1, 2, 3, in reality. However, this board has to decide whether or not to grant the D2, which is the expansion, and that's in quotes, of a pre-existing non-conforming use, because they're not expanding it, they're shrinking it. And they're changing it as they expressed tonight. If you feel that that change, it's called a change, doesn't cause any substantial detriment, and it will continue to accommodate the existing use, then you grant the D2. Once you grant the D2, then you would grant the subdivision. Contrary, if you feel that the change in the size or that addition of the house does not continue to accommodate the existing use, then you would not grant the D2.
Thank you. So for the first one, is there an offer regarding the D2 quote unquote expansion regarding
Which is,
I'll offer.
the site? Is there a second?
Did we ever close the public hearing? Just
Oh, I'm so.
but tonight we're jumping all over.
Is there a motion to close the public hearing? Sorry.
I'll make a motion to close.
I'll second.
Yeah, that would be wrong to leave us hanging after you bring it up. Okay, Amy, please call the roll.
Mr. Fuller,
Yes.
Mr. Manel,
Yes.
Mr. Mamie,
Yes.
Ms. Talerico,
Yes.
Mr. Cuccinero,
Yes.
Mr. Puccioni,
Yes.
Madam Chair.
Yes. Okay, and will someone offer regarding the D2 variance for quote unquote expansion?
I'll offer.
Is there a second?
I'll second.
Amy, please call the roll.
This would be with all the conditions in Mr. Matlock's letter, as well as the additional condition of any changes triggering a site plan requirement.
Understood. Mr. Fuller motioned,
Yes, I offer.
and
I second.
okay. Amy, please call the roll.
Mr. Fuller,
Yes.
Mr. Manel,
Yes.
Mr. Mamie,
Yes.
Ms. Talerico,
Yes.
Mr. Cuccinero,
Yes.
Mr. Puccioni,
Yes.
Madam Chair.
Yes. Okay, thank you.
And now, someone needs to.
I'll make a motion on the subdivision.
Second. Amy, please call the roll.
Yes.
Yes.
Mr. Mamie,
Yes.
Ms. Talerico,
Yes.
Mr. Cuccinero,
Yes.
Mr. Puccioni,
Yes.
Madam Chair.
Yes.
Thank the board.
Thank
For
you.
its time, and I apologize for how long it took.
You get to go.
Okay, Mr. Kirk, I believe we're moving on to.
Yes, we are.
With Kane, okay.
Kane Brewer. We need to get 2 cases in this evening, not 1.
Okay. The next carried case is Kane Brewery, Block 176, Lot 1 and 2, 1750 Bloomsbury Avenue, Ocean, Zone I1. This is an application to expand an existing brewery consisting of 3 buildings on 2 lots that will consist of manufacturing, distributing, tasting, touring, office, and retain spaces as well as food service. Many variances and waivers are being sought. The attorney for the applicant is Jennifer Krimko.
Before that, Madam Chairman, I believe there's going to be an application made by number 5. Was that 99? Your fingers on there. 199 Highwood Road, LLC.
I'm sorry, which?
No. You're looking at Vienna.
Oh, that's
1900 North Monmouth.
okay. Vincent Vianney. Which is this one? Oh, that was off already.
Yep.
I missed that.
I'm sorry, are we doing number 5?
No.
He's gonna ask for an adjournment.
Ask for an adjournment.
Oh.
No, we're going to Kane Brewers.
Yeah, because don't forget, in all fairness, I believe that the brewery application is going to take at least an hour, right?
Yes.
Okay. So for the public's information. So okay.
Yeah, Richard Tilton on behalf of the applicant, Vincent Vianney, 1900 North Wanamassa Drive. We asked that the matter be carried to the October 20th hearing.
October 20th.
Need to renotice, etc. So we'll give extension of time. Gotta go home.
Okay, any objections?
Give an email.
Okay, it will be carried.
And Mr. Ettinger, do you want to make an application?
Yes, please.
He's number 4.
In the application, since I understand that we're not going to be reached tonight, I think it'd be practical to get a new date.
October.
You would move up to a carried case instead of a new case, all right?
Yes.
That's good.
Will that automatically go to October 20th, or?
With
Yes.
sign.
Okay.
So on both cases, and I don't think we said this on the prior one. How do you pronounce that?
Vianney and Chami.
Vianney and Stephen Chami, both of those cases will be carried to the meeting of October 20th without the necessity of any further public notice or publication.
Okay, very good, thank you.
And what about Alon?
That's up to you.
What time are you closing down
As
tonight?
soon as you finish the brewery.
Well, then I would have to be carried, wouldn't it?
We stop at 11, right?
Well, we stopped,
I thought 10.
That's
10:30.
10:30.
No new cases after 10.
First of all, I want to apologize. I had no intention of participating so much in the first one because I knew that you guys would be sick of my face by the time we got to the end of this night. So I apologize for jumping in so many times. With regard to the Alon High School, is there a way, and you're already going to mad at me, so you're going to get even more mad at me. Is there a way that we could have a special meeting for that?
I can't promise anything. The thing is, we have the Donner application, which is another special meeting. If this board wants to meet once a week, we can do so, but I don't necessarily believe that that's their intent.
I don't
So,
imagine that's going to be, but
all I can do is say that I will have conversations with the board as to their availability.
Fine.
And do the best that we can.
But and meanwhile, just carry.
yeah, no. So I would like, I just like to stress, because it's for summer camp and the hope is to have it done for this summer. There are some time constraints involved.
Wait, I'm sorry. This summer and we're in September?
Yeah.
By the time you get a
By
contract.
the time, if we're limited to 45 minutes at a pop, it could take 3, 4, 5 hearings. So,
Then we'll be in summer.
right. So again, I'd like permission to speak with Ron about a special meeting, but in the meantime, have it adjourned to the October 20th without further notice.
Okay.
Without further notice.
Correct.
Be carried.
So I would just ask those people who are here for Elon.
This gentleman has a question.
Sir.
Why don't we get a notice?
For which one, ma'am, sir?
The alarm.
Because the way it works is that the applicant is required under the municipal land use law to notify you of the hearing by way of certified mail if you're within 200 feet and publish in our official newspaper, which is the Asbury Park Press. Once that occurs, we have a meeting. Then it becomes anybody's obligation to find out what happened to that meeting, whether it's continued, whether it's carried, whether it's started. All that information is on our website.
I understand. So
There will be no further notice. The applicant is not required to notice a second time, as long as it's carried at official meetings.
20th of October.
Yes.
And if it's another date other than that, meaning a special meeting, we would be required to notice.
Right. Unless we know the special meeting date at a regular
And
meeting.
it's announced at the meeting.
Yeah, but it's your
If
obligation.
you're interested, come on the 20th would be the suggestion.
Yeah, or you can always
Check
check
our
with
website.
Amy, call Amy before that, or check on the website. We try to keep it updated.
Thank you.
Okay, Ms. Kremko.
Thank you. Good evening, everybody. Again, for this application, Jennifer Krimko, this time on behalf of the applicant, under the name Kane Brewing LLC, I believe. This is an existing brewery with distribution, warehousing, tasting, as well as a retail component, existing on the corner of Sunset Avenue and Bloomsbury, taking place in 3 different buildings. What we're proposing tonight are some modifications to the buildings, reorientation of the interior, fixing up of the exterior, physically connecting the buildings on the south side, some significant parking improvements, as well as some outdoor decking space. All of that is permitted and would otherwise have us in front of the planning board. The one distinction that we're asking for that requires a use variance is a food service use in a very small portion of the building. Since that food service use is not an accessory to what we are making there, so for example, your ordinance allows you to have an accessory use such as beer tasting because you're tasting the product that's being manufactured there. That's a permitted use up to a certain percentage. But since we are not a food production facility or food production warehouse, the idea of introducing food here, albeit under a separate entity and a separate operator, technically requires a variance, even though it will be an accessory to the beer tasting and the beer use. So the application before you is for preliminary and final site plan approval, a use variance as it relates to the food use, and as you'll hear, multiple bulk variances, most of which are existing conditions, which are just being modified through this. Additionally, we need a parking variance. We did submit a traffic report, and we have the traffic engineer here to testify. And before I move anything in, and I know that Bill and Ben might want to, I know.
Jim.
I'm sorry.
Nice. Nice.
You got Ben right this time. Darn it. Not all of you were here in the day of Bill Fitzgerald for 30 years, 20 years. I heard Bill Fitzgerald in my ear. In any event, I just want to let you know who's here so you know who's going to testify to what. I have Michael Kane, who is the owner and proprietor of the umbrella company, Kane Brewing, and all of its subsidiary companies. I'm going to have him start because I think, having grown up here my whole life and my office is literally within walking distance, I didn't know they existed here. So I think it's important for you to understand what the current operation is in order for you to understand what the proposed operation is going to be. So I'm going to start with Michael, have him go through that. I have the site engineer, we'll go through all the site changes. I have not that we're going to get to it all tonight. I have the traffic engineer who will go over basically the parking variance, and we also have the architect to speak to the building improvements and the facade signage. And then finally, as is always the case, we have the planner to be the cleanup hitter and tie it all together and offer you testimony for the variances. So would you like me to move things in or turn it over to Jim and Ben?
If you can provide us a brief
normally, I would read my report in advance so the board can understand everything. It's a 15-page report. It's after 10 o'clock. When I get to page 5, you'll all be asleep, and I may be also. There's a lot of variances with this application, and I want to caution the board to realize that you're acting as a planner, not as an accountant. And just because there's a lot of variances doesn't mean it's a bad application. I testify before a lot of boards in other towns, and the board members sit there and say, there are too many variances, cut down on the variances, and they don't look at the totality of the application and whether or not it's a good application or not. You can have a very good application with 20 variances, and you can have a horrible application with only 1 variance. So I caution you not to be caught up in the number of variances, but to look at the application as a whole. I think probably it's best in this instance to let the applicant make their testimony and have their experts refer to, as far as my report goes, to the aspects in my report. There are some aspects of this application with the presentation that are confusing. I had trouble reading the plans in some instances, and I think those things can be cleared up through the testimony rather than have me read a report and get you even more confused than I was. So I think really it's best to let the applicant go forward, but Ben may have issues that he wants to describe to the board.
I'll just say that my report touches on several things. Some of the key points Jen already brought up, but that I want to hear testimony on are traffic, and they have a traffic expert. The parking associated, with their traffic report, specifically the loading area. It's kind of a little confusing, as Jim mentioned. There are some issues with stormwater management and the requirements for additional soil testing. And then landscaping and lighting. There are some buffers that need to be discussed, and some issues with the lighting levels on the site. That's in a nutshell generally what I want to hear testimony on and what the board should be looking for.
Just one request that I have. I normally try to go through and kind of check off. If you can just, if there's still concerns that aren't addressed, just at the appropriate time, just please bring them up if you don't hear responses. Okay.
Thank you, Madam Chair. So to jump right in, Amy, A1 is the preliminary final site plan revised through April 6, 2022. Tell me if I'm going too fast. A2 is the survey prepared by Dynamic dated February 7th, 2022. A3 are the architectural plans prepared by Austin Design Architecture dated April 7th, 2022. A4 is the traffic impact and parking assessment prepared by Dynamic Traffic dated April 4th, 2022. A5, oops, let me write it on this one. A5 is an aerial map exhibit by Dynamic Engineering dated 8/18/22. A6 is a color rendered site plan, also by Dynamic, of the same date. A7 Okay. A7 is a chart prepared by my client I'm gonna hand it out because I think as he goes through his testimony it'll be confusing without seeing the numbers in front of you. So A7 is a chart of the total site employees by company breakdown by hour. And A8 are the hours of operation by site by the operating business. And all of this, I promise you, will make sense once I introduce you to Michael Kane and have him sworn. So if I can trouble Mr. DeGennaro with starting the process of taking one of each and passing them down.
They'll be cool.
You want me to start on the other end? Okay, you can hand them back. So with that, I'd like to introduce Michael Kane, have him sworn, and get started.
Okay, can you please state your name
Michael Kane.
and raise your,
Michael Kane.
and if you can raise your right hand, do you affirm to tell the truth, the whole truth?
Yes.
Okay.
Michael, your relation to this application, you're the principal in Kane Brewing LLC, which is the applicant and the owner of one of the subject properties.
Yes.
And you were the individual who prepared the written description of operations, which we included in our application packet?
Yes.
And you also prepared the two exhibits that I moved in as A7 and A8?
Yes.
Okay. So, in your own words, tell the board who is Kane Brewing, what operates under it, how long you've been there, what you do, and most importantly, why are we here? What do we want to do in the future?
Sure. So,
Michael, for a big guy, you're very quiet.
sorry.
Put it right up to your mouth.
So, is that fine? All right. So Jen already talked about the site. It's 3 buildings. One is at the corner of Bloomsbury and Sunset. That is 3430 Sunset. Can I show them?
Yeah, of course. Take that mic that's there. Just Hold it close to your mouth.
So this is 3430 Sunset, corner of Sunset and Bloomsbury Avenue, 1800 Walker Avenue.
Turn the mic on. There you go.
1800 Bloomsbury Avenue. So these are the three buildings we're going to be talking about tonight. I just wanted to sort of lay them out because it gets confusing as we go. Right now, when the project's complete, they'll be home to 4 different businesses operating on the site. There'll be Kane Brewing, which currently operates there, Kane Distributing, which is currently operating there, Field and Oak, which I'll get into what that is, which is operating within Kane Brewing right now, and then the food service business that Jen mentioned. So that's what we're working towards ultimately.
And when you say the 4 businesses, except for the food service business, all of them really fall under the umbrella of, they're different entities, but they're all part and parcel of the same brewery use.
What was the third one?
It was called Field and Oak.
It's in the application form. It's right there.
Right. So, yeah, so I'm going to run quickly through sort of the history. We started with Kane Brewing Company. That was formed in 2011. It was formed by me and my wife here in Ocean Township. We started operating at the 1750 site, which is the building in the middle. It was 1 unit at the time, about 7,000 square feet. The purpose of the brewery then was to obviously brew beer, distribute beer within New Jersey. So we operated a production brewery, we self-distributed our beer throughout New Jersey, and then we had a small retail component that we did tours, tastings, and we sold beer to go. That was where we started. Our license from the ABC New Jersey allows us to self-distribute our beer, so we were self-distributing our beer under that license under Kane Brewing. In 2017, we moved our distributing business into the 1800 building when a space opened up. When we moved it over there, we got a separate license for that as a wholesaler, and that became a separate entity called Kane Distributing. Basically, we do the same thing, just under a different name. So we distribute all the Kane beer that's made under Kane Brewing, under the name of Kane Distributing. The reason we did that is we can also now distribute other beer with that license. So we bring in really limited amounts of other breweries' beers from other states. Mostly our friends who have breweries in different states. We bring it into New Jersey and distribute it to bars and restaurants. That was the main purpose for getting the separate license. It was also in a separate building. That was in 2017. In 2018, we created what was a sub-brand, which is what we referenced before, called Field and Oak. Field and Oak is it's a spontaneous beer side project that Kane Brewing has. So it's just a separate brand within Kane Brewing. It's inspired. The only reason we named it separately is because the way the beer is brewed, it's very different from the beer we make at Kane Brewing. And ultimately, down the road, we'd plan to separate it out as a separate company, which is why we're here. We would be splitting that out into a separate building, which we'll get to, so that we can do tours and tastings, and it's the way the ABC in New Jersey would require us to do it.
But it's still the same use. It's the brewing and distribution.
So the beer's made at Kane right now. We're talking about right now. The beer's made at Kane. It's stored in barrels. It's packaged, and we sell it there. It's a very different brewing process, which is another reason why we're separating it. It takes up to 3 years to make some of these beers, whereas like the Kane beers you can make those in like 2 weeks. So that's why we created that as a sort of separate brand. Right now, those beers are currently being sold at Kane. So those are the 3 entities we're operating right now. Obviously, the food entity is not in operation. That's something we're planning to do going forward.
Okay, and just let's talk about that. So right now, you have tasting areas where people can sit and taste the beer, and you, instead of having them bring food with them, you just want to be able to have someone there who can provide food for them.
Yeah, basically, as our license from the New Jersey ABC that we have, we're not allowed to sell or operate a restaurant or sell food. So, as part of what we do in the tasting is we'd like to be able to provide food to the customers, sort of as an ancillary use to the tasting, and that's why we're here trying to get a small portion of the building allowed for that use. I referenced earlier, Kane Brewing started in 1 unit there in 1750. Over time, we sort of expanded into different units as we've grown. As of 2020, we ultimately acquired all of the sites, and so the site with all 3 buildings. So as of right now, Kane Brewing as a company is operating production in 1750, and we're using 1800 for storage and offices, and the Sunset building is also for storage. Kane Distributing is located in the 1800 building, and then the Field and Oak beer that we make is made out of Kane, which is in the 1750 building. So that's how. Go ahead.
And currently, where are the tasting areas?
There's one tasting area, and it is in the original 1750 area that we opened 10 years ago with.
During COVID, when the state passed emergency regulations and allowed for outdoor dining and the like, you basically had an outdoor area in the front.
We did. We have an outdoor area in the front parking lot in front of the 1800 building, right there.
Okay. And of these three companies and the three uses, I think this is going to be important for purposes of the parking testimony. Let's just talk about the varying out. They don't all operate the same hours every day.
They don't.
Okay.
So, what you have here, which one are you looking at?
This is A8. Is the hours of operation.
So this is the hours of operation by these entities we talked about. This is proposed. This is not obviously what we're doing now because we don't have a food service business and we don't have retail, a separate production and retail space for Field and Oak. But what's proposed is under Kane Brewing, we've broken it out into operations, which is just the accounting, marketing, office functions that will operate 9 to 5. The production team, which is obviously the guys who brew the beer, package the beer, that operates 5 a.m. or will operate 5 a.m. to midnight. And then the retail side will be 11 a.m. to 10 p.m.
And when you say retail, that's both the tasting as well as the sale of any accessory type products.
Yes.
Relative.
So people come in, do a tour, they do a tasting, they can buy a 4-pack to go or a T-shirt or whatever. That falls into the retail component. And this is first page is weekdays, just for weekday operation. Kane Distributing is 4 a.m. to 5 p.m. That's the plan there. That which I didn't get really into the use, but the basics of that is we store finished beer, we load it on trucks, the trucks go out, they make all the deliveries throughout New Jersey, and then they come back and bring back like empty kegs and anything else that's in there. So that happens from 4 a.m. to 5 p.m. The early start is just to load the trucks are out by 8 or 9, and they're back by 5. Field and Oak will be will be moving to operate out of the Sunset building. That will be both split into production and retail. The production side, the beer will still be brewed in Kane and will be brought over to the Sunset building for aging and bottling and conditioning, and then sold there, similar to what we're doing now at Kane, which is tours, tastings, and retail sales to go. And that will be, the retail component would be 9 a.m. to 10 p.m. And then the proposed food operation is 9 a.m. to 10 p.m. as well. On weekends, which is important probably later for the parking, is the operation that Kane Brewing on the second page is closed because we don't operate on weekends. The brewing production is closed. Retail operation will be 10 a.m. to midnight. Kane Distributing is closed because we don't do any distributing on weekends. We don't do any production of Field and Oak on weekends. And then the retail component there is 10 a.m. to midnight.
Actually, it should say 12 a.m., right? It says p.m. So everybody
I'm
cross
sorry.
that off on theirs. It should be 10 a.m. to 12 a.m.
Right, to midnight. I apologize. And so the hours of operation on these three units, the two retail components of Kane and Field and Oak and food and service, the food service are 10 to midnight.
Okay, before we start going through the employees and how they're staggered, from an operations standpoint, when is your retail component currently the busiest? On the weekends?
Yes.
And at the evenings?
Saturday afternoon.
Okay. And those are the times when all of the other operational aspects of Kane Brewing are not functioning?
Correct.
Okay. And what we did was we went a step further, and I asked the board now to look at what we moved in as A7 into evidence. And what Michael did was he prepared the max number of employees by company by hour, so you could see when the peak employees would be there versus, as you're going to hear through the testimony, when the peak public would be there. Because that's going to be very important when you listen to the traffic engineer as to how the site can accommodate it because of the complementary uses, almost like a shared parking, because they're not all there at one time. So just, without going through it in great detail, during the week, your peak times for everything, for the Kane Brewing, Kane Distributing, and Field and Oak is between 9 and 5.
Yes.
Okay, so in the mornings it's much lighter, and after 5 o'clock it's much lighter by way of employees.
Yes, and it is probably important to point out in Kane Distributing, 5 of those employees at the peak time we have 15 employees listed. 5 of those are our sales reps who are like the brewery maybe 10-15% of the week. So they're out in the market selling, going to accounts, visiting accounts. So 5 of those people are very rarely at the brewery. The other 10 are the 8 drivers who do the deliveries, so they're there in the mornings, they're out with the trucks, and then the other 2 are the warehouse guys who sort of take care of the warehouse and load things.
Okay, and as far as employees on the weekends, the majority of the employees are really for the Cane Brewing, which would encompass the retail of the tasting.
Yes.
Okay.
Yep.
So there's no distributing there at all, and the high numbers of employees that you see in Cane Brewing during the week aren't there because you're not doing any production.
Correct. Yep.
So any employee that's there is purely there for the retail portion?
Yes.
Okay. So let's just, and I think that, unless the board has any question, I think it's pretty self-explanatory how the hours work, and I think that was one of the important questions that you had, Ben. So unless the board has any questions on that aspect of it, I'm gonna move on. I think you might have gone over everything.
Yeah, I mean.
And I know that the engineer is going to testify to it, but just with regard to deliveries today, how does that work?
So deliveries come in through. Our deliveries come in through the courtyard here to these overhead doors, and some deliveries come here to this building in Sunset. We have the bottom floor storage.
And importantly, on the plans that were submitted, we call it mistakenly the area between 1750 and 1800 was labeled beer garden, but that area itself will not be for patrons. The beer garden are the decks off the back of those buildings.
Yes. So the proposed use is that there will be some retail use here with outdoor decks or patios or whatever functioning right here and here off these buildings. This is labeled beer garden. You probably can't read it, but as the courtyard, this is not the beer garden. This is what is supposed to be listed as outdoor space for people, for patrons to be in.
So
they will not be wandering around the parking lot.
So you're not going to have a scenario where you have a beer garden in the middle of a parking lot where cars are coming in and out.
No, not at all. And we just discussed how now trucks come in and use these overhead doors for deliveries. The proposed usage will be there on the I guess the front or back, however you want to look at these buildings. There's overhead doors here, so. Delivery trucks will be coming in this driveway, delivering whatever they need to deliver, grain, hops, whatever, through this overhead door. And if anything needs to come into this building, there's no overhead door on this side where they would come in and load through this ramp here, or this overhead door here. So there would be no heavy traffic through there.
Okay, and
just clarification, the beer garden then is going to be on the second level?
Yeah,
That's
it's a
on
raised,
the second level?
it's like a raised deck, if you will. That's going to be
basically ground level, but a raised deck.
It'll be at the same elevation as the building. So when you walk out, it'll be about 3 or 4 feet raised.
Okay.
It's not in the parking.
Right, and that's why there's ramps here, so you can get up.
Okay, I just wasn't sure if it's going to be second level or first level. So it's first level.
First level, yes.
Okay.
Yep.
Okay, the architect I'll go into in greater detail. So as far as operations, what's existing and what's proposed, recognizing you haven't gone through the plans yet, you don't know what the interior is going to look like, just generally. And Mike will be here all night. Are there any questions based on what he testified to, or can we jump into the engineering and really see what's happening on this site?
Just a quick question. The spaces that are at the, I guess that's grass, who's parking there? No, right there.
This parking is planned to be employee parking. So people come in early, they can park in there and stay there. Or for truck parking over the weekend, we can leave trucks that we don't use over the weekend.
Customers will not be allowed to park there.
This will not be customer parking.
It won't, and as you'll see through the architecturals, it won't be accessible to customers. It's connected in the front, and it would have to be opened.
There's a gate, if you will, here that would not allow customers to come in.
Okay.
Or drive in, I should say.
Any other questions for Mike?
And Jennifer, the traffic expert, will talk about the number of trips in and out in terms of loading and unloading.
Yep.
Yeah, okay. Yeah,
and also, oh yes, the traffic engineer.
Yes.
I'm seeing the pointing going that way.
Okay.
Any other questions? Looks like the public's all with us, except for Mr. Dorsman. You have any questions? Okay. All right. Thanks, Mike. But don't leave.
My next witness is Mark Whitaker, licensed professional engineer.
Mr. Whitaker, if you can raise your right hand, do you affirm to tell the truth, the whole truth?
I do.
Okay, and have you testified before this board?
Actually, I have not testified in front of this board, ironically, but I've testified all through New Jersey. I'm a licensed engineer since 1993. I've testified probably over 50 municipalities throughout the state of New Jersey. Some of these locals, Eatontown.
Jen, his microphone.
Yep, turn your microphone on.
Is it on
I'll
now?
accept. Hold it closer.
Is it on?
Sounds good.
Yeah.
It sounded like it.
Yes. Yep.
You can hear?
All right. We did submit him as an expert in engineering.
We'll accept.
Okay.
Thank you.
So what I'd ask, Mark, is for you to go through basically in a little bit greater detail the existing site, what we're proposing to do by way of changes, where we comply and where we don't, and try and hit as many points as you can from Jim's letter and Ben's letter, in the hopes that they can check it off and not have to come back.
Sure. So I'll start with Exhibit A1. Is this A1?
Yeah.
The aerial map?
No, the aerial map is A5.
A5 aerial map exhibit dated August 18th. Just to orient everybody, I'm sure everyone's familiar with Kane, but for the record, the north is to the right side of the plan and Bloomsbury Avenue is on the bottom of the page. This site is located on Bloomsbury Avenue in an industrial corridor and at the intersection of Sunset Avenue. Both Bloomsbury and Sunset are single lane municipal roads. Essentially in the surrounding area is industrial uses with Brielle Avenue to the west beyond and the Seaview, former Seaview Square Mall off to the south of the site. The property is known as Block 176, Lots 1 and 2. Lot 1 is the property that's closest to Sunset Avenue, and Lot 2 is the property at the end of Bloomsbury Avenue. It is located in the I-1 light industrial zone, and the property area is 4.045 acres. As Michael indicated, if I put this exhibit up, overall site plan rendering.
That's A6.
A6. There's 3 existing buildings at the site used for Kane Brewing, Kane Distribution, the Field and Oak, and offices. There's currently 4 full movement driveways on the site along Bloomsbury Avenue and 2 depressed curbs which act as our loading areas, which are in front of Sunset Avenue. And there's a total of 93 parking spaces under existing conditions. Topographically speaking, the site has significant grade change from a westerly direction in the back of the site to easterly direction towards Bloomsbury Avenue. There is an existing timber retaining wall behind 1750 and 1800. And there's a limited on-site conveyance system associated with stormwater management. The majority of the site just sheet flows off into Bloomsbury Avenue. As Jen indicated, I do want to point out some of the existing nonconformances because there are many existing nonconformances and many of our variances are associated with them. As far as bulk standards, we currently have a minimum front yard setback existing nonconformance to Bloomsbury Avenue where 50 feet is required and 49.7 feet is provided from 1750 and 49.9 feet is provided from 1800. We have an existing minimum rear yard setback existing nonconformance where 60 feet is required, and both 1800 and 1750 are approximately 40.2 and 40.1 feet. And then there's also an existing nonconformance associated with the existing 1750 and 1800 separation, where those buildings are supposed to be separated the height of the buildings, which is 25 feet, and they're less than 25 feet. We also have existing nonconformance in what we call the central parking lot, which is between 1750 and Sunset Avenue. No off-street parking space is backing into an entrance or exit drive shall be closer than 25 feet to the street line of Bloomsbury Avenue. Right now, those parking spaces are directly on the right-of-way line of Bloomsbury Avenue. We have existing nonconformance associated with parking for visitors being permitted in the front yard of industrial uses. We do have parking currently for employees in the front yards. We're not permitted to have loading. Loading is supposed to be in the rear yard. We're currently loading in the front yard along Bloomsbury Avenue in front of Sunset. We have 2 existing nonconformances associated with the quantity of curb cuts and their position on the site. Your ordinance only allows one curb cut permitted on the street frontage, and it shall be located within the center 1/3 of the frontage of the site. As I indicated, there's 6 existing curb cuts, 4 full movement driveways, and 2 loading zones or loading areas. Also in an I-1 zone, you're permitted up to 2 curb cuts located no closer than 10 feet to the side property line. Again, we have 6 curb cuts, and the driveway closest to Sunset Avenue is directly at the right-of-way line. And lastly, as far as existing nonconformances, there's minimum 25-foot wide landscape area shall be provided along front property lines. Right now, the existing buffer along Bloomsbury is approximately 4.5 feet, and at the narrowest point along Sunset, it's 3 feet. Moving into the more positive things as far as what we're proposing to do here, the project proposes interior and exterior renovations to all 3 buildings with minor additions and proposed canopies and the raised decks, which will be the beer gardens, which Michael testified to. Those will be basically in the notches of 1800 and 1750 on the south side of the site. The buildings will continue to be used for warehousing, manufacturing, office space, the retail sales, tasting areas, and the food service, which is not permitted in the zone. Access to the site is essentially going to remain the same. We are proposing 1 new full movement driveway, which Michael had testified to, associated with deliveries along 1800. That's where the grain silos are and the spent grain silo is. So we provided a full movement driveway at that location. The 2 driveways that are in the central parking lot, we're improving those driveways by putting curb returns on those. The driveway that's existing between 1800 and 1750, we're actually going to chain that off and propose parking across it. So it's not going to be a normal driveway that you could drive through. It would only be for future purposes if Michael needed some bigger piece of equipment or a truck to enter straight on to access 1750 and 1800. We just didn't want to lose that driveway, but it won't be regularly used for customers or employees. We've improved the driveway that's in the Sunset parking lot, which is closest to Sunset Avenue, and the 2 loading zone driveways will remain the same. We are, I'm sure you're familiar with the site, but there's pretty significant grade change in this central parking lot. Actually, a lot of cars have actually scraped their bottoms, and you can see that in the parking lot. We're actually going to be redesigning this parking lot to make it a more even grade from the back of the site to the front of the site. So it'll be a significant improvement across the site. And as far as other site improvements, we're proposing new mechanical equipment, which will be in the rear of 1715 and 1800.
Why don't you just pull up the aerial just so they can see how there's really nothing around it and
Sure.
the topo and no impact?
Yep. So the mechanical equipment behind 1800 and 1750 is basically screened by, first of all, that's the grade that goes up to our westerly property boundary, and then there's overstory trees on our property and on the adjacent property, so it's not something that would be readily seen from any adjacent properties. And also the grain silos that are at the corner of 1800, our immediate neighbor to the south is also fairly wooded, and there's no existing use there right now. As far as bulk variances associated with the buildings, we are exacerbating the building setbacks. So 1800, there's going to be a canopy in the front of the building. So we are exacerbating the front setback to 41.9 feet where 50 feet is required. In 1750, there's a slight expansion at the corner of this building. So that's going to go to 47.3 feet where 50 feet is required. In Sunset building, we have a canopy for a loading in the corner of the building. That would be the northeast corner. So that setback would be 31 feet where 50 is required. And we're also providing a patio with a fence in the front. This is going to be an elevated patio for field and oak tasting. So that measurement is 24 feet. As far as the minimum accessory rear yard setback of 60 feet, like I said, we're providing silos and mechanical equipment back here, so that is going to be within the required setback, and that'll be 26.5 feet to this property line.
That's not existing.
I did touch on all the access associated with the new application. We do have some variances associated with the access points. They're the same ones I described in the existing nonconformances, where only one curb cut shall be permitted on any street frontage. As I indicated, we are providing one new full access driveway, but we're also somewhat closing one of the full access driveways and only be used for cane brewing should they need to get a bigger vehicle in between 1750 and 1800 buildings. The curb cuts in your ordinance are supposed to be a minimum of 15 feet wide and a maximum of 30 feet wide. I measured the driveway widths as being synonymous with the aisle widths across the site. So the only two driveways that exceed that are actually our loading zones, which are basically depressed curb in front of the loading docks in front of Sunset. So there'd be two variances associated with that.
Can I just correct
Sure.
that testimony? The driveway width is one thing, but the curb cut is the width of the curb. The width at the property line. So if you have a return radius that gets wider than the driveway width, that's what your curb cut width is.
I understand what
so
they-
it's a little bit over the 30 feet.
Yeah, that's fine.
My comment was that with minor adjustments, you can eliminate that.
If you measured at the curb cut, I think they're going to be significantly.
I meant at the property line, not the curb cut.
Okay.
If it's measured and your return radius begins before the property line, so the width of the driveway at the property line, which is really what is intended with the ordinance, is wider than 30 feet.
So you're suggesting just limit the
Yeah,
radii?
just straighten it out a little bit. It's just a minor adjustment.
That's fine.
And it's really not that big a deal one way
Sure.
or the other, but it does eliminate a variance.
Mark,
No problem.
just to keep things moving along, when it came to parking, you did the calculation as if
What?
every
Yeah.
single use in the building was operating at the same exact time based on square footage.
That's correct. All the parking requirements are based on square footage.
Okay, so.
So the parking requirement totals 203.
Okay, so, and we're providing how many on site?
109.
Okay, and again, that would be if all the offices were occupied, all the manufacturing, all the warehouses, all the tasting areas, all the retail, all at once.
That's correct.
Okay, and as was the testimony from Mike, that doesn't happen and it's actually overlaps and is pretty complementary.
That's correct.
Okay, and that's gonna go into greater detail with the traffic engineer, because he did actual counts based on the uses today and then extrapolated out. And then the same parking variances that we had, the same as listed in Jim's report with regard to the setback of the parking, improving some.
We're requesting a parking variance associated with the parking stall depth for these angled parking spaces. This is a one-way aisle in front of 1715 and 1800. We're providing 19 feet where your ordinance requires 21 feet, but we're also giving 2 extra feet to the aisle where 16 feet is required. We're providing 18. We'd rather have the aisle be wider than the parking stall depth because there's a clear overhang over the curb. So Justin can also testify to that, but we would prefer to keep the dimensional requirements of the one-way aisle and parking as proposed.
And then lastly, with regard to the grading, we're changing elevation more than 2 feet, as you had indicated, to clean up the site and remove some of those steep slopes. And as part of that, we need some wall height variances in the rear yard and the front yard. The rear yard one is up against that slope and the height faces into the site, correct?
Correct.
So there's no impact.
So there's a
on the site.
retaining wall behind 1800 and 1750. The low side is actually on our side. The high side is on our neighbor's property or to the west. So that retaining wall is 8.65 feet at its highest point, plus we'll provide a safety fence on top for a total of 12.15 feet.
And you indicate there's a front yard fence, wall fence at 11.5.
So that's
where is that?
basically where the loading docks are in front of Sunset Avenue. The steepest point is the corner of this loading dock and the adjacent lawn area that meets up with Sunset Building, because this is at a higher, the north side of Sunset is a higher elevation than the south side of Sunset.
Okay, but it's not the type of wall that typically the ordinance addresses, meaning it's not a perimeter wall that's affecting any neighbor, it's just basically creating a loading zone.
Yeah, it's more
actually
dug
attached
in.
to the building.
It's more dug into the ground as opposed to a freestanding wall of 12 feet in the front yard.
Okay, pedestrian circulation, is everything connected to sidewalks and is it gonna be
Yes,
safe for pedestrians?
It is. It's going to be an improvement on pedestrian interconnectivity at this site. We basically brought the sidewalk down from Sunset Avenue, which is fairly steep, but it follows the grade. And then we have crosswalks through the facility in the central parking lot connecting to the buildings and also to 1750 and 1800. with the proper ADA parking in each of the parking lots for the accessible entrances.
Okay, and you talked about the silos and the other mechanicals in the back. We're also proposing a new trash enclosure.
There's a 10 by 20 trash enclosure in the southwest corner of the site. Basically, that's where Michael will use it for operations, and it's adequate capacity for his operations.
Okay.
Is that the only trash enclosure for the whole
It
site?
is. We actually discussed that with Michael, and he says if he needs to have it come pick up more frequently, he would, but it should be adequate. It's actually bigger than what he has now.
So the people in the Sunset building, are they going to be like walking the trash all the way across the site to the opposite corner?
We would bring.
Give him the mic.
Since we're already moving things around the site a lot, we would just do the same thing as we're moving packaged beer from one building to another. We bring garbage back from one building to another and have it all located in the back. We mentioned before, we're currently have pickup twice a week with this will be a larger container, and we have the ability to go 5 days a week if we just need pickup every day to clear the site. That would be what we would
Well,
do.
right now it's in a centralized location, and that's
Right.
all the buildings go to one location.
Right now, it's back in the courtyard
Right. So
between
that's-
70 and 1850.
Operation will be the same.
Right.
Okay, let's just speak about stormwater management, what we're proposing, and
Sure.
Again, let's start with, can you address all the concerns in Mr. Matlack's letter with regard to stormwater management?
Yes, we can. Basically, the concern is the new stormwater management regs providing adequate soil testing data within each of your stormwater management basins. Obviously, when we design the site, when we go out to test the site, we don't know exactly where those basins are going to be. So some of our borings are in slightly different locations in the basins, but yes, we can comply.
So there's no exception.
I have
So
no
then-
issue with that.
So then
whatsoever.
without going into it in any great detail, since Mr. Matlack's already reviewed it, just generally speaking,
Sure.
how are we handling stormwater, and isn't it better than what's happening
It's
today?
definitely better because, as I indicated, pretty much everything just sheet flows off of Bloomsbury Avenue. So just very quickly, we have a bioretention basin in front of the Field and Oak patio, which will collect water from the loading docks. We have an underground system, which is between Sunset Avenue and 1750, which picks up stormwater from the roofs. And then we're using pervious pavement all in the front in these angled parking spaces in front of 1750 and 1800, and these parallel spaces that are primarily going to be used for employees off on the south side. Those are all hydraulically connected and run to a discharge point into Bloomsbury Avenue.
And it's obviously better than what's existing there today.
It is, and it meets all the regulations.
Okay, and utilities, all the same utility connections?
Yeah, we're maintaining all the existing utility connections, and they're all public in Bloomsbury Avenue, and there's a water line that runs out to Sunset Avenue.
Okay, and obviously this is a fully built-out site, so we can't really create new landscaping, but we're landscaping where we can. So let's just talk about what we're maintaining and what we're adding.
Yeah, since we are pushing back this, we're putting these mechanical equipment and the retaining wall, we did have to remove some trees in the back on the west side of the building. There's a couple trees along the north side of 1750 that had to be removed. In total, it's 46 trees, and your ordinance requires us to replace that with either one 4-inch caliper tree, two 2.5-inch caliper trees, or a donation to the Shade Tree Fund. We've looked at some of the comments from Mr. Higgins, and we can probably add some trees back, so we're anticipating adding some additional trees here. Right now we have 4 shade trees along Sunset Avenue, and we have a shade tree at the end on the south end of the site on Bloomsbury. We can probably add some additional trees along the frontage, and we might be able to add some trees behind Sunset.
So if the board were to approve this, we'd be comfortable with subject to satisfying Jim with regard to landscaping?
Yes, definitely.
Okay, and while we don't technically meet the landscape buffers along the side and the front, we do have the percentage landscaping required for the site overall.
We do. It's required to be 25%. We're at 27.76% for the overall site. The only thing we don't meet is the requirement for 30% of that to be in front yards. Obviously, we can't meet that along Bloomsbury because it's already developed almost all the way up to the Bloomsbury Avenue, so we got up to 25.2%.
Okay, and obviously we can't meet the side yard and rear yard buffer just because it's already developed.
Yeah, we're making that a little bit worse on the south side on Sunset with the addition of this aisle and these parking spaces, but it's pretty much consistent along Bloomsbury, but we're actually adding shrubs along Bloomsbury, and it's fairly consistent along Sunset Avenue.
Okay, and we need some technical variances as it relates to lighting.
We do. So we're using a combination of like wall-mounted gooseneck lights, under-mounted canopy lights, area lights, and pathway like pedestrian lights through the whole facility. The variances that we seek are associated with the proximity of the area light poles to the property lines. As I indicated, we don't have a lot of room here to provide buffer to the property line, so those light poles are on the along Bloomsbury Avenue and along our southern property line. So those setbacks.
And it being in an industrial zone, everything around us is warehouse or industrial use, and none of it have nighttime uses.
Exactly. So basically, the lights along Bloomsbury are going to help light Bloomsbury Avenue, but there's no adjacent uses that would be impacted by that. So the other thing is we have some variances associated with maximum foot candles at the property boundary. Again, since these area lights are right on the property boundary, it's almost impossible to meet that. But it's only a few instances where it exceeds your ordinance along Bloomsbury and this southerly property line. And then we exceed the maximum horizontal illuminance, the average horizontal illuminance, and the max to min. And essentially it's because we're lighting up this courtyard area better than it is now. So we've provided a lot of wall packs, and there's also gooseneck lights back here. So there's some higher values that throw off our average horizontal luminance and the max to min uniformity ratio.
But overall, we're not going to have a negative impact on anybody else, meaning we're not shining into anybody else's property or creating an issue for them.
We're not. You're not even going to see these lights from an adjacent property in the west, in the courtyard area, and everything else is oriented towards Bloomsbury Avenue and the additional industrial uses on the east side of Bloomsbury Avenue.
All right, and let's talk about the signage.
Sure.
And you have one of the sheets from your plan here that you could
Do.
put up. I think that would be helpful. And just so the board remembers, the corner site on Sunset, I believe, is where Nelson Engineering used to be. And there's that giant concrete monolithic structure there. So I just remember that as we go through the testimony.
So we're proposing 2 freestanding signs, which are, this is sheet 26 of our site plan set. Mark it as an exhibit.
No, it's part of the set.
2 freestanding sign. One will be Kane Brewing, one will be Kane Distributing Company. Those are located both on Bloomsbury, facing like basically traffic on Sunset Avenue. Those are 80 square feet. In total, they're 8 feet high by 10 feet wide. We do have variances associated with them on a corner lot. You're permitted 1 sign per frontage, but since both of our signs face the same frontage, it's a variance. And the area of those, the area is a little bit complicated. The area calculation in your ordinance is a little bit complicated. It's related to the amount of front yard setback that you provide. And so since I indicated earlier, this patio is 24 feet from the property line. We're only permitted 24 feet. But on a corner lot with 2 signs, they have to be 75% of that dimension. So they're only allowed to be 18 square feet. And like I said, it's 8 by 10 signs at 80 square feet.
And I'm sure that the planner will testify this, but for a parcel this big, this 18 square foot sign wouldn't even be seen.
Completely. It'd be way too small for this type of use in this area. The other 2 signs which are not permitted in your ordinance are roof signs. It's because they are basically mounted on top of the roof, and it says Kane Brewing. Those signs will be located on 1750, so the Kane will face Bloomsbury Avenue, and then the Brewing will face the internal central parking lot. And we do have architectural rendering, which will show that a little bit nicer. So those are just not permitted signs because you can't have a sign that projects above the roof line. And then we have a total of 8 facade signs. Your ordinance allows each business on the site to have 1 facade sign per street frontage, so we're technically allowed to have 6 signs, and we have 8. So one is the Kane Brewing Company, which is going to be on above the canopy on 1800. So there's a canopy here, and that Kane Brewing sign will be directly above that. There'll also be a tap room sign along that frontage, which is on the canopy, and then another tap room sign, which is on basically the portion of that canopy that faces the sidewalk. The office sign, which is similar to the tap room sign, will be on a canopy in front of 1750 to identify the office location for the building. We have the Kane distribution sign, which will be on the Sunset building in this location. And then the Cane Brewing sign, which is going to be on the gate, which is basically between 1750 and 1800, which will be normally closed. That's in
And the
in this
architect
location.
is gonna go through this a little bit
Yep.
more, and you'll see it in context.
And then the 2 Field and Oak signs, which will be on the fence around the patio at Sunset.
Now let's talk about the big concrete monolith.
And it's basically a mural. So this is the mural, which is it's an existing feature on the site, which is located at the end of the Sunset parking lot on the west side, and basically proposing to
Paint it.
paint it. Right. And we're gonna do both sides, right?
Yeah, well, one of the suggestion, I think, from Jim was to do both sides. It would
Yeah.
be more attractive, so that's fine.
Yeah, just explain that as an existing structure, it's not a new structure.
Right, that's why I
Just
brought
a-
it up in the
yeah,
beginning.
yeah, see.
We're just gonna make it look pretty and tie it into the site a little bit.
And basically, for all of the facade signs, we're permitted 10% of the area of the facades, which calculates out to 1,496 square feet, but no sign is permitted to be greater than 150. Our total is like 406, so we're well below what we're permitted for facade signs. But we do have the 1 Cane Brewing sign, which exceeds the 150 square feet. That's 318 square feet. So it's basically, it's very long because it includes Ocean Township, New Jersey, Cane Brewing Company, estimated 2011. So it's 79.5 feet long, but it's only 4 feet high.
And I'm assuming the architect will discuss the scale of the signs
Absolutely.
in relation to
And I was
the
just
size
gonna
of the building.
I was just gonna say that based on the size of the building, we actually have less signage than we're allowed to have. It just needs to be a little more spread out because the building's so big. I think that, lastly, there was a question with regard, we went over the hours, the deliveries. How does that typically work?
I don't know that I would leave the hours of delivery to Michael, but I will clarify all the loading zone because I know that that was a question in both letters. So right now we have 3 existing loading docks, basically on the south side of Sunset. We're adding 3 loading docks, 2 which are basically the loading dock that's on the north side of all these loading docks, and then we're adding 1 at the corner, which will be at the higher level of basically the second level of the building, and that has a canopy over it. All of these, what appear to be, which are loading docks now, are not going to be loading docks in the future inside of this courtyard area. So there's no loading docks inside the courtyard area. We are adding a loading dock on the north side of 1750, which will be accessed from the central parking lot, and we're adding 2 loading docks on the south side of 1800, where this aisle was, where the grain silos are and the spent grain silos. So anything else on the plan that looks like a loading dock is not. So we'll clarify that on the site plans when we resubmit.
Okay. Are there any engineering questions?
There probably are from me, but I can't process it this
No, Ben, do you have any engineering concerns?
I do. Let me see. A couple of things that I want to just make sure that we cover from my letter. In the beer garden area, or the parking area that's shown as the beer garden, you have those 10 spaces, and there are stairs kind of right next to the parking areas. I have a couple of notes similar to this, just some changes to the plans. For example, installing bollards there. There are some places where handicap ramps should be installed. Is it safe to assume that you can comply with those design changes?
There's no handicap ramp in the courtyard area, but yeah, we can comply with all your comments associated with these 10 parking spaces. I think you said bollards,
But
and
also putting the bollards up by the stairs.
and
all
right, and the
safety
striping
things.
at the ends, and that'll be for employee use only.
Okay.
I think you may have been talking about
Yeah, right in
ramp
front
here.
of
This
the
is all
buildings
depressed
there.
curb, so there's no need for a ramp, but I can
Okay.
clarify that on the plan.
Okay.
Yeah, there was nothing in, I can stipulate that there's nothing in your letter that we can't comply with.
Agreed.
We went through a point by point.
The only
Said another way, in the positive form, we will comply with your letter.
Excellent.
Jim's report indicates that he needs more information on different things, so I don't know how you want to handle
Well, before we do that, so the two lots, are they going to be consolidated? Is that
Yes.
Okay? And will that be a separate application, or is that
Well,
part of this?
No, well, you don't need board approval for lot consolidation. It's just done by
No, it can be a condition of approval.
if the board requests it. We will either consolidate it or file cross-access easements to ensure that the two lots are always used together. I have to speak to my client about.
I don't know about financing and stuff.
Right, about
Maybe,
financing
yeah,
and stuff, we may not be able to consolidate them, but we'll certainly tie them together by deed.
Okay.
Got it.
The driveway, I guess the curb cut directly across from the entrance to that beer garden. So you said there's going to be no loading areas in that parking area?
No, inside the courtyard.
But so what trucks are going to be using that and getting?
No one really. It's normally going to be closed. Michael just didn't want to lose it in case he had to do some large piece of equipment and needed a truck. It'd just be easier to come straight in between the buildings as opposed to trying to make this turn.
Okay.
So we didn't want to lose that opportunity, but it's normally going to be closed, and we'll have.
It's not going to be used as a loading area, but it's just in case
he needs to get a crane or something like that. We just want to have that access.
A lot of the equipment that's used here is really quite big, so if he needs to replace a piece of equipment and a crane needs to come in, or a very large
Nothing's
truck
going to be able to
has
make
come
a turn from this one-way aisle into that, so we just wanted to keep that
in.
as
But it will be
for future
chained
use.
during everyday use.
Okay.
So there's a curb cut in front of it.
It's already there. We just don't want to lose it.
Yeah.
We actually proposed parking right over it, so.
So, how do you?
Okay, well, there's things in my letter and my report that say we need more information, but I think what the thing to do is wait till we get all the testimony, and then I'll go through my letter and find out what hasn't been addressed.
Right, because
and we can go
I'm
through
pretty sure
yeah.
that by the time we finish all
Yeah.
our testimony,
Yeah.
we're gonna have addressed everything. in your
Probably. I would think you have addressed most of it anyway.
Yeah, I think that covers everything in my letter related to engineering aspects. I do have some more questions for the traffic engineer when he comes up, but I'm good for right now.
Is it appropriate to? I'm sorry. Were you finished?
I'm finished.
Okay. To end here, or pause here, I should say, and
Well, is anybody?
You guys all shaking heads. I'm like, I'll stay here till 3. I don't care.
get my words out.
But no public hearing.
No, I know.
Yeah, but yes, the engineer will come back if you think of any questions. I mean, listen, I'd love to go all night because we waited to get here, but I recognize that I think Jim's asleep. His eyes are
I'm halfway there.
His eyes are open,
Yeah,
but I'm not seeing a whole lot there
there's-
anymore.
There's
So-
no light up here.
Yeah, so I see Mr. Manel shaking his head when
Absolutely. I got to teach tomorrow.
when you said let's end it, so I'm not gonna push. So I guess it's gonna be a big night in October, huh?
Be on vacation then.
Well, let's carry to the 20th without further notice for right now, and if we can't get coverage, we might not finish, but we'll do our best.
Yeah, okay.
That's okay.
What's your
Yes.
I don't think anyone here cares once they can get out.
Even though there's no public here, I would ask Madam Chair to just announce it, just for the record. That would
Announce it that-
Case is carried.
Oh, the case is carried till October 20th with no further notice.
Thank you.
Get down.
A motion to
Jen,
I'll make a motion to
Adjourn?
when we do
adjourn.
this,
Second.
go in the order that's in his letter. Well, it's hard to figure out.
Your voice work.
All in favor? Man, I'm so tired.
I can figure out what variances though. Let the planner go.